Good morning, everybody. Happy Tuesday. Welcome to TCF Live. Nice to have you all here a few minutes early today. Let's get started with Judge Middleton.
All right, Elizabeth Conway. Yes, good morning, Ms. Conway. Good morning. Are you Elizabeth May Conway?
Yeah.
And we've met. I'm Judge Middleton. You're here. I kind of lost track of you. You got evicted from your house and I didn't know where you were.
Yeah.
But you got a ticket for being a disorderly person in Three Rivers on January the 9th. Let's take a look at that ticket.
It just says trespass on it.
Let's see what it shows here. I think this was at the hospital.
Yeah.
All right, the ticket says trespass, that's correct. And it's a form of disorderly. It was 2 o'clock in the afternoon at Three Rivers Hospital. Conway was previously served trespass notice to location, issued citation for trespass. How do you plead to that charge?
Oh, not guilty. Because they still see you as a mother. You can still go CC as a. Oh, okay. Yeah.
Ms. Conway, where are you staying?
My Aunt Britta's in Constantine.
All right, so
And
you're
then
at your aunt's.
In hotels.
And hotels?
Yeah.
Do you have any income?
Yeah, I get disability and I have other incomes than that.
I didn't realize you were getting SSI.
Yeah.
Because you've got a number of unpaid fines from other stuff.
Yeah.
You got $945 worth of unpaid fines.
That's why my license got suspended because I missed my payment.
You were on a payment plan,
Yeah.
and I think you might have made a payment in January. Anyway, have a seat for a minute. Mr. George, the city attorney, stepped out. We'll see what his thought is on this case. I didn't realize you got SSI. I'm glad you at least have some income.
Yeah.
But it's awfully expensive to spend it on hotels.
Right.
All right, you sit down for a minute and we'll wait for Mr. George to come back. Sarah Pattison. Just a minute. Good morning. Are you Sarah Jo Pattison?
Good morning, yes, I am.
You got charged with no insurance. We get lots of those. File 26124. No insurance is a misdemeanor. It's punishable by up to a year in jail, a fine of up to $500, not less than $200. Plus costs, which would be a minimum fine of $325. Do you have insurance now?
I do.
Do you have it with you?
It's on my phone.
All right. Who's your carrier?
Progressive.
Very good. Do you still live on Erie Street?
Correct. Yeah.
You got $403 worth of unpaid tickets. You got a real old seatbelt ticket from 2007, which is $78. Surprised your license isn't suspended. Then you got allowing another to violate the motor vehicle code that you haven't paid from 2024. You owe $325. We can wipe that out with a jail sentence, but I'm assuming you'd rather pay the fine.
Yes.
All right. You haven't paid anything on it. Did you forget about it?
No, I did pay on it.
Let's take a look.
I was making payments and then lost the job and didn't get back into paying the payments.
Okay.
But I made several payments.
All right. Well, let's get back into payments. Yeah, you made a payment. You have that real old unpaid ticket. What's this? Got a domestic violence case. And they gave you a court date of 2/17. We should have caught that. Laura, we got a open arraignment for Sarah Jo Pattison, 26194. She has a court date of 2/17. We'll save her a trip and take care of that today. So I'd like that. It fell through the cracks. Sarah Pattison, 26194. Also, we'll have somebody talk to you about your insurance. So have a seat for a minute and we'll come back to your case. I didn't do a very good job of checking these files. All right, David Banks. Good morning, sir.
Morning.
Sure, you is Mr. George. This is another ordinance case. Thank you. Good morning, sir. You David Banks?
Yes, sir.
We've met, but I need to identify you for the record. You got charged with retail fraud 3rd degree. It's alleged that in November 11th of 24 and February 1st, that you did a retail fraud at Dollar General. I'll read it the way it's written. It sounds like an underscan, although while the store is open to the public, transfer, remove, replaces, conceals, or otherwise misrepresents price at which property is for sale. Did alter the price of merchandise which was offered for sale for less than $200. This was authorized by Mr. George.
Is it just one count, Your Honor?
Well, I'm trying to figure it out. It was reported at Dollar General, tore off a label from a Mike and Ike package, which is some cheap candy. 10 separate packages of Mike and Ike being scanned in place of other merchandise between 1/11 and 2/11/24. Dollar General employees documented the item stolen by reviewing video surveillance. Totally, the amount of merchandise stolen was $555. The video surveillance shows Banks holding a barcode in one hand at the self-checkout, scanning it in place of other items. 2 incidents, one on February 11th and one on January 11th. So they issue this warrant, and then you don't get served on the warrant for a year. They entered the warrant in July of 2024, and they didn't serve it on you till January of 26. The whole time, did you live on 5th Street?
Yes, sir.
No, I got a warrant, and then they never bothered to do anything with it. This is a little complicated. It involves video evidence, identifying you, multiple incidents, criminal history of previous R&C charges. This is the kind of thing you could probably benefit from having an attorney appointed to represent you. It sounds like they're not going to reduce this to a civil infraction. Sounds like it's a planned scheme is what the allegation is. So would it be your choice to plead not guilty and have me appoint a lawyer for you?
Yes.
All right. Plead not guilty. I don't know why it took them 1.5 years to serve this warrant. They go to all the effort to get it. You're living at the same house. They never bothered to serve a warrant. How'd you get arrested when you got arrested in January?
Well, my car was sitting on the street, and police just ran the plate. And since the car's in my name, the warrant popped up.
I think you've been in here between then and now.
Yes, I have.
You've been in here with some other people, bringing them to court or moral support. You've been in here while there was an open warrant and nobody even knew about it. I would have arraigned you on it if I'd known about it. But yeah, you've been in here between. Anyway, Mr. George, this is David Banks. It doesn't look like the type of case you would reduce to a civil infraction.
Probably not, just because of the amount.
It's complicated, so I got an attorney for him and set an attorney pretrial. One troubling thing is they got the warrant in July of 2024, he lived at the same house the whole time, and they didn't serve the warrant till accidentally it got served in January of 26. That was always a Three Rivers thing. It's been better since the new chief is there. All right, plead not guilty, appoint an attorney. Set attorney pretrial for March 6th. Another gonna be a busy day. I just better assume on the first Friday of each month, I'm not gonna get any lunch. All right, Mr. Banks, we'll get an attorney to help you with. The good news is there isn't a warrant out hanging over your head. The bad news is there's an allegation of a calculated scheme to steal stuff. Maybe if you hadn't used Mike and Ike's every time. I didn't know anybody even ate those anymore. All right, you go with a court officer, we'll get a lawyer, and I will see you on March 6th. It's your obligation to call a lawyer, make an appointment to discuss it with them prior to that date. All right, you go with officer. Mr. George, Elizabeth Conway is here. She pled not guilty to that trespass charge at the hospital. I didn't know what you come up to the podium, if you had any idea on what to do with it.
We'd be willing to do a civil infraction.
All right. All right, Miss Conway, what you're charged with is a misdemeanor. It's punishable by up to 90 days in jail and a fine of up to $500. Mr. George, the city attorney, would dismiss that charge if you pled to the Three Rivers ordinance disturbing the peace as a civil infraction. It's like a speeding ticket. It wouldn't be a crime. It would be a civil infraction, and I would give you a fine of $100 and put it on a payment plan with the other stuff that you're currently not paying on. So they would dismiss the misdemeanor if you pled to the disturbing the peace as a civil infraction. The allegation is that you've been barred from the hospital, which is a rough gig, and you went back there that day at 2 o'clock. So they dismissed the misdemeanor if you plead to the civil infraction. Are you willing to accept that plea?
No,
No?
no. I still go there. I still go there to see the hospital there. They see me there. The last time I went there, they were singing a different tune. They felt actually like they did something wrong.
All right, Mr. George, you have any more insight on it?
This was from January 9th of this year.
Yes.
The hospital should have previously served a trespass notice by Sergeant Fuller in September of 2025.
And you're saying you still go to the hospital since this?
Yeah, they see me there. One of the charity guys actually, in January, when the day I was like at that time before I was trying to beat the hell out of me too. So I was very improper the way they treated me.
All right, well, why are you going to the hospital now?
Because I had physical assaults,
So you're going there for medical treatment?
medical for a seizure medicine, and like or have a seizure, or I was physically assaulted, like I was in a neck brace and then stuff like that.
So have you been there since January 9th?
Yeah,
When was the last time she was there?
a week ago. Cop took me in.
Who took you in?
Officer Britton, I think.
All right. Well, I'm just gonna set this for a bench trial. 1 hour. I want you to go out to the counter. I want you to talk about your unpaid fines.
Okay.
I'm not gonna appoint a lawyer for it because I'm not likely to put you in jail for this. I don't need to set a pre-trial for it because it's not gonna change anything. They've offered a civil infraction, which is as low as they can go. And you're not willing to accept that. And the irony of it is you've been to the hospital since this, taken there by a police officer, if your story is true.
Yes.
Payment plan and current contact information. All right. You do have some income and you can make some sort of monthly payment on all these previous things. I could wipe them out with a jail sentence. We got an open in talks where you have $325 way back from 2022. You have a domestic violence. It looks like you may have been paying on that one. You have a retail fraud.
My retail frauds are dismissed, remember?
I don't know. This says it owes $170 and you have a no insurance. You're on a payment plan.
You dismissed all my retails like last May.
All right. Well, the court officer will take you out to the counter and we'll address those matters. Aubrey McCall.
Good morning once again, everybody. It is Tuesday. You have arrived at TCF Live, and it's great to have you here. We're going to ride with Judge Middleton for just a little while longer as other courts are just starting their day. Programming note, we are not doing the 4th hour today, just 3. Beth and I have a call that we have to take today that I need to make time for, so 3 hours today.
They alleged that you were going 40 and a 25
Yes, that's what he said.
on Broadway. That's easy to do down near Dad's place. And that you don't have a driver's license.
I do. My license, I was about 18. It was suspended for unpaid tickets. I had just really had my license. I didn't know much about that. I paid the fines to get it reinstated. There was a hiccup with the Indiana BMV. I've since then taken the steps to get that taken care of.
So you have a valid Indiana license?
Yes,
But you live in Michigan.
yes. I just moved to Michigan not that long ago.
All right. Do you have proof of your Indiana license with
I
you?
don't at this time. No, I can bring it the next court date, if that's possible.
Well, we can do a next court date.
Okay.
I'll try to take
Or
care
when,
of it.
however, whenever I can get it to you guys, I can do that.
All right. How do you know you have a valid Indiana license?
I've called and I went to the DMV.
Or did they give you something?
They gave me a paper, but I don't have it right now.
Well, that's not very good. You
I
live right
know.
here in Centerville.
I know.
Um,
I walked today.
okay. What does the paper say?
It's just a paper stating that I had to go do a knowledge test again after I paid the reinstatement fees in April of 25. I didn't know I had to do a knowledge test, which I went and did, and it was the paper stating that I passed that and that I do have a driver's license again.
Well, there's a problem. You don't live in Indiana, but if you have a valid Indiana license, it's valid in Michigan. I guess it's not terribly inconvenient. You just walk back over here. Let's set this out a bit and you'll bring in proof of license. Is that acceptable, Mr. George? It's not hard to speed right there at Broadway. So 25, I think they write lots of tickets right there.
There was, it was snowing out and there was a bike he didn't have any lights on. It was dark out and he was going around me. So I kind of had to swerve around him and I got really scared.
I'm glad you didn't hit him.
No, me too.
All right, today is February the 10th. Let's continue this to February 24th.
And I can bring the proof in then.
Yes,
Okay.
8:30. Defendant will bring proof of insurance. Michigan used to suspend your license for not paying tickets. Frankly, I was in agreement with it. They had two kinds. FCJ means failure to comply with judgment. And if you got a ticket and were convicted and didn't pay it, they would suspend your license. There was another one called FAC, which is failure to answer citation. If you got a ticket and never showed up, they would suspend your license. They don't do that anymore. So there's not a lot of incentive for people to pay their tickets.
Right.
But Indiana will still suspend you
Yes.
for not paying a ticket.
And like I said, I was 18. I just got my license. I didn't know much about tickets of that sort. It was my first one.
Well, there's a chart. If you get this, it could suspend your Indiana license and jam you up for Michigan. So Mr. George is gonna consider reducing these charges if you bring in proof of insurance or proof of a license.
Okay.
Tuesday, February 24th. 2026 at 8:30. Pre-trial conference. Bring proof of license. What do you do, Ms. McCall?
Right now I just clean like family, friends' houses, as a cash paying job. I have 2 children, so, no transportation at this time either. So I'm just trying to kind of get things in order. To be
You
able
live
to
down
work.
here at the apartments?
Yes, and I'm applying to the nursing home right here in Fairview and hoping to get in there. I'm a CNA as well.
All right, well, good for you.
Thank you.
That, I wouldn't be a bit surprised if you got a job there, and that would be handy. Not a lot of places to work in Centerville.
Right.
All right, here's your notice. Put that on your refrigerator.
Thank you.
I'll see you in 2 weeks.
Okay.
Mr. George will be here and you bring proof of your Indiana license.
Okay, see you then. Thank you.
You're good to go. Thank you.
Thank you.
Once again, everybody, good morning. Welcome to TCF Live. Happy Tuesday to you. Just an FYI for those of you out there who are regulars in the community. I mentioned this in the pre-show, but not all of you were there. Wahoo reached out to me yesterday and wanted me to let you guys know that he will not be here this week and probably much of next week. His sister passed away yesterday. And he wanted me to let you guys know that so you weren't worried about him and wondering where he was. But if you're a person of prayer, please hold up him and his family in your prayers. Let's change things up. Let's go to, we'll stay in Michigan, but let's go to Judge Mom. Say good morning to her.
In the area of Eureka, when the officers observed a red 2005 Buick a Michigan license plate, Edward Robert 1214. They conducted a law enforcement information network search on the vehicle's license plate and learned that the vehicle did not have insurance. They activated their emergency equipment to effectuate a traffic stop and then approached and made contact with Mr. White. They explained the violation, reason for the stop. Mr. White did in fact produce his driver's license and expired proof of insurance from back last month in January. The officers went back to the patrol car to issue a violation. Prior to that violation being issued, Officer Brad Smith, who's a canine officer for NDOT, showed up on their traffic stop and at a assistive backup capacity and used his partner to do an open air search where he indicated the presence of narcotics. Officer Smith notified both officers Sloan and Stathakis of he and his partner's findings. They reapproached and made contact with Mr. White and asked him if there's any contraband. He said no. They asked for consent. He declined to consent, but based on the open air sniff, they had him exit the vehicle. He had no narcotics on his person, but Officer Sloan searched the vehicle and located a cellophane clear bag with white powdery substance in the door pocket, which a searching narc cocaine ID swipe kit revealed that it tested and it reacted positively to the illicit drug cocaine to the tune of 4.49 grams with packaging. In addition to a pair of brass knuckles in the door pocket of the automobile as well. There was also located some psilocybin mushrooms that also were tested with a narcotic kit preliminary and also tested positive for psilocybin. The vehicle, Mr. White was arrested. His vehicle was impounded. He had money on him that the officers completed forfeiture on, and he was booked and lodged. And in addition to the said charges, is a HAB 4. Thank you, Judge.
Thank you. Upon examination, complaining witness, I find the offenses charged were committed and there's probable cause to believe defendant committed those offenses. Counsel, your appearance, please.
Good morning, Your Honor. Attorney Corey Westmoreland appearing on behalf of Mr. White.
Thank you. Mr. White, your name for the record, please.
Shane White.
All right. And counsel, as to the arraignment.
Yes, Your Honor. At this time, we are prepared to waive a formal reading. My client stands mute.
Sir, the court will waive the formal reading. You do have the right to have an attorney represent you. If you are unable to afford an attorney, you may have one appointed to represent you. And you, in fact, had an opportunity to speak to an attorney today, correct, sir?
Yes.
The court has also signed the petition in order for appointed attorney in felony matters. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have a trial by a judge or by a jury, and you also have the right to remain silent. Anything you say orally or in writing may be used against you in court. Do you understand those rights, sir?
I understand.
The court's going to enter a plea of not guilty on your behalf. Schedule this matter for probable cause conference on February 19th.
9:45.
9:45 a.m. And counsel, as to bond.
Yes, Your Honor. I would like to know that Mr. White currently is residing in Lincoln Park. He is gainfully employed full-time working at Key Construction. He's not currently on probation or parole, has no other pending matters that we're aware of. And after speaking with Mr. White at length this morning, he did assure me he would be appearing at all future court dates, has no history of absconding, and understands the importance of showing up. I would just ask that all that be taken into account when assessing a bond.
All right, sir. And you're not out on bond in any other jurisdiction? Sir,
I am not.
are you on probation or parole anywhere?
I am not. No.
If you were to test right now, sir, what's in your system?
Cocaine.
All right. And you have, you're being charged as habitual fourth offender in this matter. You also, in addition to your felony matters, have another misdemeanor possession charge from 2007. Another, oh, you have assault, dangerous weapon. Those were both dismissed. Who do you reside with, sir, at the property?
That is my mother's home at the moment.
For how many moments have you been at your mother's home?
Just had a recent breakup, so I've been back there probably within the last month.
Okay. And so that's the home on Detroit Street?
Yes, it is.
And where did you reside prior to that, sir?
In Taylor.
And so you pay your mom rent?
Yeah, I do help her out. So I recently signed a lease for an apartment in River Rouge, but I haven't moved anything in there, and I've only paid the first month. But I haven't moved anything in there. So I didn't think that was important because I'm not staying there. And after this, I probably won't be staying there.
All right. And Detective, would you like to address bond?
Just based on the severity of the charges, one alone is at $25,000 as far as maximum. So I think it's more than prudent for 25,000, 10%. But thank you, Judge.
Okay, the court will take into account that Mr. White is charged as a habitual fourth offense in this matter. And as such is looking at least for one of the counts, up to life in prison. The court will also note that Mr. White has prior weapons charges as well as possession charges. And the court does find, based upon all that, that the court wants to ensure that Mr. White is going to return to court, as well as to ensure the safety of the public and to ensure that Mr. White is following the conditions of this court. The court's going to order a $25,000, 10% bond. You are not to possess or consume any alcohol or drugs unless prescribed. You'll be subjected to random testing, sir. So upon your posting of bond, you are to contact into probation to set up your random testing, sir.
I understand.
I think it's 13.
All right, we'll see you back on February 19th. Thank you. Have a
Barbara, thank you for the $5 super chat and for the 5 gifted memberships. Great way to start the day, and I appreciate that. And I agree with your sentiment and your words in the super chat.
You just spoke to the one individual, correct?
That's correct. I just received the other information on Mr. Harvey and Coleman.
Okay. All right. So I'm not sure if we're doing those right now or not. I don't know what the court officers are doing, but Detective, if you want to come back in here and do your sign on before you have to get to your next spot.
Thank you, Judge.
Did you have all those files there? Thank you.
All right.
Thank you. Okay.
A little heavy.
It is a little heavy. Okay. All right, Mr. Berry, I'm not ignoring you. I'm just going to have to check in a few more people here. Bobby, are you grabbing another individual out from in the back? Okay, thank you.
Hey, you guys are here, pretty home.
The iPhone that just joined, please turn on your camera and tell me your name.
Rhonda Locklear.
Okay, turn on your camera, please.
That's a whole iPhone.
Okay, thank you. And Mr. Katz, I'm sorry, Mr. Borkin, this is one of your matters. So I'm going to rename her.
Should we head back to breakout room 3?
All right, well, they get things sorted out. We'll probably come back to her later, but let's go to Florida. Say good morning to Wade Mercer.
Yeah.
Locke and Mr. Kirkland, I'm seeking at the same time because your cases are identical for first appearance purposes. Each of you are accused of violating terms of your state probation. Mr. Locke, you have a no bond warrant signed by the circuit judge. Mr. Kirkland, you have a no bond warrant signed by the circuit judge. I don't know that your warrant has been served, Mr. Kirkland, because the warrant was just signed yesterday afternoon. But I'm going to go ahead and arraign you on it because I want to go ahead and get you a lawyer appointed if you're asking for one. And then they'll get it served to you hopefully today. Mr. Locke, would you like to have an attorney appointed to represent you?
Yes, sir.
Mr. Kirkland, same question.
Yes, sir.
I'm going to appoint the public defender's office to represent both of you. I need you to listen to Mr. McDaniel in just a second. We'll see if you have any questions. Mr. McDaniel.
Your Honor, we're going to plead not guilty. I set this in the March 5th court docket and I advise the attorney from the public defender's office to come by and visit as part of that hearing.
Thank you. Mr. Mitchell, anything?
Just that Mr. Kirkland's court date will be the 3rd, since the new law violation is a new law felony violation.
And it's already been filed, or he's already on that docket already?
Yeah, so.
Okay. So, Mr. Locke, do you have any questions, sir?
No, sir.
All right. Wish you the best. Mr. Kirkland, do you have any questions?
No, sir.
Wish you the best, sir. The next case is Christopher Miranda So, Sergeant Applewhite, in Mr. Miranda's case, there was an outstanding warrant, but the sheriff's department system had some issues yesterday. I'm not sure what happened, but Mr. Miranda has a violation of state probation, no bond warrant in case 24092. So we need to get that served on him. So, Mr. Miranda, you've got a charge of violation of state probation. We're going to come back to in just a second. Before we get to that, you have a new charge of retail theft. I've read the complaint on the new case. There is probable cause for the new charge. I'm going to appoint the public defender's office to represent you in that case. Please listen to Mr. McDaniel.
You talking too much. I already took a plea.
You haven't taken a plea at all. That's what we're here for, to try to resolve it. So listen to Mr. McDaniel, and we'll see if you have any questions in just a moment. Mr. McDaniel?
Your Honor, I've talked to Mr. Miranda. We're going to plead of no contest. The charge is listed. You understand he'll be sentenced to 6 months in the county jail. We have 1 day jail credit, a $370 fine, reserve on any restitution. He has signed a two-way form waivers right to jury trial and call witnesses.
Thank you. Mr. Mitchell, is that agreeable with the state?
It is, Your Honor, and I did want to bring to the court's attention, I looked again, there's one review case out there for Walmart. In addition to this one, the extra restitution in that review case is $83.52. We can add that to this plea, and I will decline to file on the review case.
So if he agrees to a civil judgment for an additional $83.52, you will not be filing, you'll be dismissing the other retail theft from Walmart.
Correct, Your Honor.
Mr. Miranda, did you hear all that?
Yes, sir.
And any questions about any of that, Mr. Miranda?
83.52.
And is that the plea you would like to enter, sir?
Yes, sir.
Mr. Miranda, I'm going to accept your plea of no contest to 1 count of retail theft, sir. Adjudicate you guilty. Sentence you to 6 months in jail, court costs and fines of $400. Total restitution of how much?
370 fines.
370 court costs and fines. 83 is not total restitution though, is it? No, there's restitution in this case too. It was non-resellable product.
Here, I'll add it up right quick.
That wasn't mentioned. Yeah, Mr. McDaniel, did you get restitution in this case?
I didn't get
Yes.
it. I mean,
It's in the complaint. It's 145.57 in this case.
I've got a total amount between this and the review case of $229.09.
Civil judgment for 229.09. Mr. Miranda, if that's still what you want to do, is it?
Yes, sir.
Okay, so now let's deal with the violation of probation. Ms. Miranda, I have no idea what will happen with the violation of probation, but if you do get sent to the Department of Corrections, then this is not going to keep you here. You'll go ahead and go and serve this while you're in DOC. I don't know that's going to happen. It may, you may dismiss it for all I know, but you are accused of violating the terms of your probation. You should be served with that warrant today. And I want to get you a lawyer appointed in that case if you want one. Do you want an attorney appointed to represent you in the VOP?
Yes, sir.
I'm going to appoint the public defender's office to represent you in that case. Listen to Mr. McDaniel, and we're going to see if you have any questions when he gets through.
Your Honor, we're going to plead not guilty. He has to sit this in the March 5th court docket, and there'll be an attorney to come by and visit him for the public defender's office prior to that day.
Thank you. Mr. Mitchell, anything in Mr. Miranda's VOP case?
No, Your Honor.
Okay. Mr. Miranda, the attorney will see you before your court date. Now, do you have any questions?
No, sir.
All right, sir. Wish you the best.
What's the restitution? 2648 MRV.
What's the total restitution? Mr. Miranda's cases?
229.09.
That's both?
That's both, yes.
229.09 restitution, civil judgment. And then no bond, arraign, and VOSP. Okay, next case is Travis Smith. Mr. Smith, good morning. You're here for a hold out of Calhoun County. I took a look at the file this morning to see what it was about. It's a 2020 child support matter. It appears to have a purge on it of $2,000. Mr. Miranda, excuse me, I'm sorry, Mr. Smith, if you make that purge, you're going to be released. If you're not able to make it, you'll go to Calhoun County, and when you get there, you'll go to a 48-hour hearing. It's called a 48-hour hearing. It happens within 2 business days of you getting there. And you will, when you get there, Mr. Smith, the judge is going to ask if you could come up with a lower purge amount. So you can expect that question. You'll get to use the phone today to contact friends or family about that purge amount, to be aware that question is probably coming, because the hearing officer may or may not lower it depending upon what you got. Mr. McDaniel?
Judge, there's no objection from this court. I've already sent over an order and I've spoken to the hearing officer and stuff, releasing him. If the court has no objection to that, would ask the jail to maybe go ahead and release him. I got the order sitting there waiting for the judge to sign it now to release him. There's an IDO in place. It's been in place for several years now. He's working and so just want to put that on the record. If not, I can wait for the order to be signed, but if the court has no objection.
Yeah, then those are always tricky because you're dual role as child support, as attorney for the agency. So as attorney for the agency, and I know that it's an awkward position for you, but in this case, you're actually both attorney for the agency and his attorney. But the agent, he's been making child support payments regularly. Is that right?
Correct. And
So it's
I'm
in the
not his
best
attorney
interest.
at all. I don't want to act like I'm not his attorney at all. I'm an agency attorney.
Okay, so he doesn't have local charges. He doesn't have local charges. So you're right. You're not his attorney at all.
I'm not an attorney at all.
So tell me, who have you sent the order to? I don't know whose case it is.
It's a Calhoun County case. I've sent it and I've talked to the hearing officer, Donald Fro.
Okay, so Mr. Smith, I'm not getting involved in it. It's not my case, and I'm not the judge in the case. You wouldn't even be coming to first appearance if it was a Jackson County case. So whatever that judge decides to do, if he wants you held or not, that's up to them. But apparently, Mr. McDaniel is trying to get you out because they would rather you be working and paying child support, which it appears you're doing, than being in jail and interrupting that child support that you've been paying. So, Mr. McDaniel, I don't really have any authority or desire to involve myself in the Calhoun County case. What you work out with them is fine with me. All right. So, Mr. Smith, hopefully you're going to get out of jail this morning. I wish you the best. Any questions?
No, sir.
Have a good day, sir. After Mr. Smith, we have Angela Myers. Ms. Myers, good morning. Ms. Myers, you're here for one charge of aggravated child abuse and one charge of grand theft. Ms. Myers, I've read the complaint. I think I'm the judge that signed the warrant, ma'am. The aggravated child abuse is a very serious charge, but it's not what it sounds like. It's not as bad as what you think of aggravated child. I think it meets the minimum requirements. There's probable cause for the charge. That's why I signed the warrant. But I am aware that there are no serious injuries alleged. There's allegations of a deadly weapon or a weapon that could cause death or serious bodily injury, that being a belt or some type of excessive punishment is what you're accused of. So, Ms. Myers, let me ask you a few questions before I can make a bond or release decision. Obviously, I need to hear from the attorneys. The pretrial release sheet from the jail says you work at Washington Rehabilitation. Is that right?
Yes, sir.
How long have you had that job?
Since November 18th, 2025.
November of 18? Wait, did you say November of 18 or November 18th of 25?
25, November 18th, 25.
What did you do before that?
I was working at Econo housekeeping.
Okay. And how long did you have that job?
For like 4 months, 4 or 5 months.
You live in Mariana?
Yes, sir.
And this child that's supposedly the alleged victim of the excessive disciplining, how old is that child?
15.
Does she live full time with you?
Yes, sir. But she goes with her dad on holidays, all holidays and everything basically.
Do you know where she's living now?
She's staying with her father right now.
Okay. As of when? When did that start?
He took on last month on the 29th.
Okay. So the last question I have is I want to make sure that the criminal history I've got is accurate. The criminal history I've been provided shows no prior history. Is that accurate, ma'am?
Yes, sir.
All right. So let's see what the attorneys have, and they may have some more information for me. Mr. McDaniel, anything else in Mr. Myers' case?
Just ask the court to consider conditional release.
Mr. Mitchell.
I know it's the minimum threshold for aggravated child abuse, like you stated. We would probably be opposed to a conditional release, but not opposed to a lower bond, like maybe treat it as a third-degree felony or something like that. But nonetheless, whatever the court decides, we request no contact with the child involved.
So, Ms. Myers, let me go back and take a look at the complaint. It seems to me the allegations are disciplining with a belt but not in her below the waist. The allegations are she was struck repeatedly in the head or neck area, I believe. And that was the basis for the charge from law enforcement. So give me this, don't comment on this. I'm just wanting to refresh my memory. Her back and right ear.
Judge, I will bring it to your attention also that DCF and the CPT interview was conducted stating that during those interviews, the victim said that Myers threatened to stab her and threatened her multiple times to spray her with mace.
I do that to my kid all the time, so.
What? John.
That's a joke. That's a joke. That Judge, I mean, she's a local. She lives here. She's going to show up for every hearing. The purpose of it is not to, the bond is not, it's just to ensure that they come back to court. And I think a conditional release here would suffice to make sure she comes back to court and answers to these charges. She's clearly got some defenses to this, and with no criminal history, we'd ask the court to consider that conditional release.
I took the phone back to her.
That's all right.
Just seen her yesterday.
Yeah, I think with no criminal history, what I'm gonna do is I'm gonna go on the side of the conditional release with no history with this kind of allegations. So what I'm gonna do, I don't want to set your bond and you not be able to post it and be sitting there for weeks and weeks, lose your job, which is certainly possible. So I am going to put a condition, no contact. I'm gonna clarify that more in just a minute. So I'm gonna let you pick, but anytime I offer a conditional release, I give the person a choice because some people prefer a bond. If you want to post a bond, your bond will be $2,500 on each count for a total of $5,000. I am going to offer you a conditional release. You will have the standard conditions of all conditional releases. Plus, you would have a condition of no contact with your daughter for the time being. Now, let me clarify that. If Department of Children and Families is involved and they have some type of safety plan in place, then either myself or Judge Garcia very well may modify that and allow some contact, either supervised or limited or whatever. But right now, for the time being, no contact at all. That means no electronic contact, no telephone contact, no contact at all. But you can pick between the bond and the conditional release, Ms. Myers, primarily because of your lack of criminal history. Ms. Myers, do you have any questions about that choice, ma'am?
No, sir.
And which one do you choose?
Conditional release.
I'm going to grant you the conditional release. I'm going to ask the jail to give you a notice for your court date, which should be March the 3rd at 8:30. They're going to let you give you that notice. They're going to let you get dressed in your regular clothes. They're going to bring you to the courthouse because that's where the conditional release office is at. When you get here, you'll meet with Mr. Goodson or Mr. Ham, one of our conditional release officers. Ms. Myers, they'll explain the conditional release to you. They'll give you all the rules in writing. They'll give you a chance to ask questions, ma'am, and then you'll be free to leave. Ms. Myers, if you contact friends or family, you can tell them you can be picked up at the courthouse in 30 to 45 minutes from now. Do you have any questions, ma'am?
No, sir.
All right, ma'am. Wish you the best.
So I'm not justifying this in any way, shape, or form, but I'm telling you there's more going on here. I would lay good money on an out-of-control teenager and a mother who just reached her wit's end and broke. And I base that on the fact that she has no criminal history whatsoever prior to this. There's more going on to this. I'll be curious if we see her back, maybe in Judge Garcia's court, and see.
Here, first appearance accused of one count of aggravated battery, Ms. McMahon. There is probable cause in the complaint. And I've looked at your history, ma'am. I think it's from the state of Alabama. You have a lengthy criminal history. So I think you're entitled to a bond as far as I can tell. Let me see if the attorneys have any additional information before I address that bond. Mr. McDaniel, anything on behalf of Ms. McMahon?
No, Your Honor.
Mr. Mitchell?
No, Your Honor.
Ms. McMahon, I'm gonna set your bond at $15,000 cash or surety, ma'am, based largely upon your criminal history. You've got a condition of no contact with alleged victim. So, Ms. McMahon, if you post a bond, you can have even if you don't post a bond, I'll see if you have any questions in just a second. But whether you post a bond or not, you have no contact with the alleged victim at all. Now, do you have any questions, Ms. McMahon?
Yes. Can you get him off of my property?
If he's on your property,
get
ma'am.
my ID back from him?
If he's on your property, you have to go through a lawful.
Use that.
Yeah, that's probably wise, Mr. McDaniel.
His reflexes are getting better with the mute button.
Charles Coleman. March 3rd. Please give her notice for March 3rd. Thank you.
Yes, sir.
Well, Mr. Coleman, good morning. You're here because you've been accused of one count of fleeing and attempting to elude law enforcement and one count of driving an unregistered motor vehicle. Mr. Coleman, there is probable cause for the charges. And Mr. Coleman, I looked at your criminal history, which I want to make sure that's accurate. I've got a date of birth of 86. Mr. Coleman, it's very rare to see a 40-year-old with no prior history charged with fleeing and eluding, and there be evidence to support it. So my question is this criminal history I've got accurate? Have you really never been charged with a crime anywhere?
No, sir. And it was the brakes went out on the car is what it was. I still got.
Don't talk about what you've been accused of. I just want to know if your criminal history is accurate.
Yes, sir.
Okay. Well, the brakes going out doesn't help you with the speed. It doesn't make the car increase in speed. So
Yes, sir.
same thing. That's the problem you've got. So I'm not going to give you a conditional release. You're accused of fleeing, at a pretty excessive speed from law enforcement for quite a distance before you stop.
sir.
And I think you hit a tree is what the complaint says.
And my God.
Let me read this. Given the reference about the brakes, let me read. Yeah, vehicle made a left turn on the Florida street and again accelerated rapidly, reaching speeds of 60 miles per hour in a 35 zone. Yeah, okay. So I think you're entitled to a bond. I'm not going to give you a conditional release for running from law enforcement when there's this evidence against you, but I think you're entitled to a bond. Let me see if the attorneys have any additional information, and then I'll set that bond. Mr. McDaniel, anything? Your Honor, just said, I think he's employed in the pole barn business, and we just asked for some kind of reasonable bond. All right, thank you, Mr. Mitchell.
No, nothing from the state, Your Honor.
Mr. Coleman, I'm gonna set your bond at given your lack of history, your bond's gonna be $2,500 cash or surety. You have the right to, oh, there are 2 counts?
Yeah.
No, one of them's not gonna be that. So it's gonna be $2,500 on the fleeing and eluding, and then on the operating an unregistered motor vehicle, I'm gonna give him your ROR. So it's a total bond of $2,500 cash or surety. You have a standard conditions of every bond, which are don't miss any court dates, don't be charged with any new crimes. Mr. Coleman, the jail's going to give you a notice for your felony arraignment date, which will be March the 3rd at 8:30. They'll give you that notice before you leave the jail, and you will get to use the phone in a few minutes. Do you have any questions, sir?
Yes, sir.
Have a good day, sir.
That one from yesterday is Caden Rebels.
Thank you. Mr. Rebels, good morning. Mr. Rebels, I saw you yesterday. I set you a bond at first appearance. I believe your father was here. After court, Mr. Mitchell made me aware that apparently I didn't, on the record, put a condition, no contact with the alleged victim. That's an administrative order that's entered in our circuit. I have to do that. There's actually a statute that addresses that. So I told the jail, or I asked the jail, if you didn't post bond, to bring you back up to date, just so I can make sure you understand that. You can have no contact with the alleged victim. Any questions about that, sir?
No, sir.
Have a good day.
You too.
Corporal, that's everything I had on my list. Anything else from the jail this morning?
No, sir.
Mr.
That brings an end to our day with Judge Wade Mercer. Let's stay in the South, but let's check in on the parole board.
Appearances.
Good morning. The Louisiana Committee on Parole is impaneled at headquarters in Baton Rouge. Today's date is February 10th, 2026. The time is now 8:47. We're at the Rapides Detention Center for the purpose of a revocation hearing. And sir, would you introduce yourself and tell me your DOC number?
Okay, my name is Damon Gloston. My DOC number is 740905.
Just one moment, Mr. Gloston. Ladies, is there anybody in the room? We were expecting to see Mr. Crawford first.
No, I'm by myself.
Okay, well, just hang tight.
Yes, ma'am.
Pause and get.
All right. Well, they figure out who they have in front of them. Reminder tonight, sidebar, 8 p.m. Eastern, 5 p.m. Pacific, right here on this channel. I believe tonight's topic is inspired by the person who showed up drunk in front of Judge McNally the other day. So we're going to talk about people showing up for court intoxicated, because that was not the first time that we've seen that, and it certainly will not be the last. So please join us again, 8 p.m. Eastern, 5 Pacific, right here on TCF. We are a couple of minutes in the Wayback Machine, so let me knock this forward a little bit and see if we can get past whatever this delay is. Oh, it's a big delay. There we go. I think we're running now.
Questions and ask you to enter a plea. And we also do have your agent, Brandon Roy, who will also provide testimony. So, Mr. Byrock?
It's alleged that you have violated condition number 4.
Oh, wait, I didn't introduce everybody. Sorry, go ahead.
By being engaged in criminal activity and are associating with persons known to be engaged in criminal activity. That the parolee was engaged in criminal activity, which was evidenced by his arrest on 11/5/25 by Jefferson Davis Parish Sheriff's Office, and the parolee being charged with unlawful use of social media, 2 counts, and unlawful presence of a sex offender and or child predator. At the preliminary hearing, you admitted and pled guilty to that violation. Do you still feel the same today?
Violation of, now, so which one, unlawful presence?
The number 4, unlawful use of social media.
Well, yes, yeah, I was on social media, but at the time, honestly, I really thought it was just Facebook or Instagram. You know, I thought it was that was the only 2. And on my behalf, some of those friends I talked to on that website knew of my sexual, my sex offender status, and no, yes.
So you actually, you admit that you did it, that you were on it, but you didn't think it was wrong. That's your statement?
Yes, sir. Yes, sir.
Okay. All right, Officer Roy, can you tell us anything about that violation?
Yes. So, I had ended up getting contacted by an officer, or by a friend of mine who works for another agency, and he advised that he had been contacted by Mr. Gloston on Grindr, which is a dating app for male people, male subjects. So I ended up doing some research and ended up getting a search warrant for his Grindr account, and the results showed that he had 2 different Grindr accounts. Which that's what he was actually charged with, was the unlawful use of social media, 2 accounts, 2 counts, because he had 2 different social media accounts on Grindr.
Other than these, how has he been on supervision? Is it easy to supervise?
He had a job the whole time that he was out. He was paying his fees and whatnot. Other than that, I had no other issues with him. He had the previous time I had supervised him, he was arrested for the same thing, was social media.
So he's been arrested before for social media violation?
Yes, sir. Yes, sir.
All right. I don't have any more questions.
So,
Does
Ms.
anybody
Singleton,
else have
do you have any questions? Mr. Gloston, would you like to make a statement before the panel would be prepared to vote?
Yeah, I just wanted to say, yeah, I knew I was on there, and just wanted to, state that, I really would like to keep my residence at my home, and my job's probably still there. And, if there is any way that, that y'all can find it, to where I could just, get out and go straight back to work and keep my residence, and, try and, basically keep this from getting out to where I have to lose my house and go re-register and all that again, really good, really good person, just made a bad mistake getting on there. But like I said, I really didn't think it was that serious at the time. Ma'am.
But you've already been charged with it previously. How did you think it's not serious?
Yeah, but this time, I told some of the people that I talked to that my sex, me being a sex offender and stuff, and I.
Yeah. But you did have a job. What's the issue with keeping your monitor charged?
Oh, with that, see, when I had my charger at work, I worked at the metal plate in Roanoke, and I didn't know it wasn't supposed to get wet. So sometimes it would, when I get off in the morning, I work 12 hours. When I got off in the morning, I'll take a shower and I'll go to sleep. And sometimes it would instantly just die, and I'll wake up and have to hurry to recharge. And then sometimes it'll get to 13%, not knowing that it will tell me I have to charge my phone. Charge my
You're not being charged with that. I'm just asking.
Ma'am, yeah, I understand. Yes, ma'am.
I have no other questions. I'm ready.
We're prepared to vote. Thank you.
Yes, sir. Yes, ma'am.
I've been assigned your case and I vote first, Mr. Gloston. And quite obvious, you just didn't follow the rules that you knew were a violation, and just coming here and admitting them, we appreciate that. However, you violated the conditions of your parole, so I have no choice but to revoke.
Ms. Stapleton.
I concur with Mr. Balrog.
Mr. Gloston, if you were not a fourth felony offender and this wasn't a problem, I would probably look differently, but you knew the rules. So my vote is also to revoke. You need to follow your conditions of parole. This case has been concluded, and that's the only business we have at that facility. Thank you.
Thank you.
Denied. To the shock of absolutely nobody. Okie dokie, let's head back up to Judge Middleton.
Let me ask you the $100 question. Do you have insurance now?
Yes,
Who's your carrier?
I count
And is your plate squared away?
for the most part. It's in the back window.
What's
I
that?
can't get the other one off, so it's sitting in the back window.
All right, so you have a valid plate and insurance?
Yes.
All right. We get lots of these. Last Thursday, we had 9 no insurance cases. They can now run your license plate and tell whether you have insurance or not. So they run the plate, this car's not insured, they'll pull it over. We get tons of these. No insurance, as you heard me tell Ms. Pattison, is a misdemeanor. It's punishable by up to a year in jail and a fine of not less than $200 and not more than $500. With state cost and this crime victim rights fee, it makes them a minimum fine of $325. There is a lesser charge known as no proof of insurance, which means you didn't have the slip in the car. That's not even a crime. That's a civil infraction. Civil infraction is punishable by a fine only, and the fine for no proof of insurance is $150. We've probably all done that if we forgot to put the slip in there. So what we do is when people like you are here and you have proof of insurance, we see if we can get the prosecutor to talk with them, have you show your proof of insurance, see if they'll reduce the charge. So you got insurance and plates. Do you still live on Hampton Road?
Yes.
I don't think we met before. I don't remember ever meeting you. But let's see if we can get a prosecutor to take a look at this. Laura, would you call down to the prosecutor's office and let Abigail know we got 2 no insurance cases where the people have insurance? So have a seat, Mr. Quay. We'll see if we can take care of this with one visit. We like to, at least I like to, try to do these pretrials what we call instantly, rather than having you take a day off work and come here again. We try to get the prosecutor to come and review this picture. So I don't have the discretion to change it. Only the prosecutor does. So we'll need their help. All right, we also have Anthony Vranzovic charged with no insurance. Let's see what his deal is. It's a ticket. He called on the 6th and confirmed the date, and then he didn't show up. File number is 26123SM. The other thing about the no insurance cases, they all have to be written under state statute because they're punishable by up to a year in jail. You can't charge an ordinance case for anything more than 93 days in jail. So these are all state tickets. Storanzovic has failed to appear. Do in order to show cause first. I don't have a phone number.
He's off for the next month. He's studying for the bar again. He's doing the
Pre-trial.
pre-trial, so
All right.
I haven't seen him, but he's down
All
there,
right.
so.
Can we let Angelique know we've got 2 no insurance cases? All right. Yeah, the bar exam is, I think it's the 25th and 26th of February. They have 2 local people taking it. We wish them the best. For those of us that did take it, nobody wants to do that again. Judge McNally he said when he retired, that was young, he was younger, that he would like to take all 50 bar exams.
Why?
I thought, who would do that? But that was Judge McManus would like to go around and take 50 bar exams.
Even the states where they've only got like 3 or 4 essays, they expect like 6 pages an essay.
I don't know. That was that was 40 years ago or more. But
You got reciprocity, I guess. it would
yes,
be
I
cheaper.
guess. All right, well, let's talk about who isn't here. We've got some more no-shows. No, I didn't, but thank you. It's just,
Came in.
oh, Mr. Oliver just came in, or this
No,
just came in?
that just came in.
All right, Justin Horrell, file number is 26161SD.
I spoke with it, it's on our radar.
All right, very good, thank you, Paul. We get good service here. The assistant prosecutor who's got the knowledge and ability is aware that you're here. She'll be here shortly to talk with you. Mr. Horrell is from Bronson. He's charged with operating while intoxicated. He got arrested on February 2nd and posted bond. These numbers never work. All right, so he didn't show up and didn't answer his phone. Try in order to show cause first. His parents named him Justin Time, Tyme, for a middle name. He's got some other baggage here. He should be here.
Yeah, nobody ever picks up their phone anymore. I know I don't unless I absolutely know the number and I want to deal with it. Well, he finds a contestant that actually wants to show up. Let's go to Texas, Judge Stevens.
No, he doesn't know.
He's got a note.
Yeah, no.
Are you Matthew Brown?
Yes, yes, sir. All right.
You're charged with a third-degree felony of stalking in 24 CR 2425, which carries with it up to 10 years in prison. It's serious. You probably know that. And Mr. West is going to help guide you through this mess. Have you ever been in trouble before?
No, sir.
You're looking down, which is always a tail sign.
I have before, it was deferred and the court ruled it to be deferred.
Okay,
Yeah,
do you still have that? Are you still on that probation?
No, sir.
Okay.
I was never on probation. I did community service.
Well, you said deferred. That's deferred.
I think he misunderstood it. Yes, he was. He's on deferred probation, I believe. It was also 12 years ago as well.
What's in the past is never in the past. That was a famous quote.
I agree with that.
That's why you learn and fix this.
Yeah, about 3-4 weeks, whatever is on the court schedule. And like I said, I had some information from him yesterday. I need to go through it in trial mode right now. So
anything from the state on these?
No, you're right.
Okay, 4, yeah.
You're 4.
Yeah. Give us this, thank you. Jason? Robert?
No, I haven't had any contact with him.
Two cases, 25 CR 1845 and 25 CR 1846. Assault on a peace officer and harassment of a peace officer. And let's see, November 9th, November 9th must have been the same incident. Second and third degree felonies. Robert B. Chason. No answer. I asked the bailiff to call into the hall for Robert Chason, please.
Maybe that's what maybe it was on his document before. I knew I recognized the name. I didn't know what it was. Wow.
And in this one, I don't think he's here.
Well, I think he missed last time, Your Honor. There's a note that we've already.
What did we do?
You issued those up here and.
No response to the name called in the courtroom. No response to that name called into the hall. Did we revoke his bond last time?
What does the note say?
What is his?
I'm looking.
What are his bonds?
Should be 40,000 each.
I think he revoked it and moved it from.
I think you ordered a GPS device as well.
But I don't think he's been in custody since then, so that's the problem.
Do recall that, and I don't, I'm looking to see if I have any notes as to why.
All right. So what I was.
His bonds are 20,000 on the 1845. Yeah.
It's going to be same on the other one, huh?
Yes.
Fine.
And I can go back and look at my emails to see why we were.
They, then it has failed to appear. His bonds are revoked. They are now doubled from $20,000 to $40,000 in each case. Plus, he must have a GPS device so we know where he is when he's not here when he's supposed to be. And that's Robert Chason. So where are you headed now?
I'm heading over to back to trial.
Which case is that?
That's Donald Kelly, the failure to register as a sex offender.
Oh, okay, that's in Templeton. Okay, like the jury?
Yeah,
Well, I'll be darned.
Yeah, we're starting.
It's so nice of the judge to help out like that. He's a very good man.
Huh?
All right, how about
We're gonna put Brent last till, we're gonna put him in December. For the December docket.
I'm good with that.
Because Christmas, he likes Christmas.
If you like, that's good, because it keeps me out of the stores and spending money.
And in the winter flavor,
I remember that now.
I'm calling your client Michael Hubbard Frost.
Yes, he's here.
Frost, Steve Frost. Famous name.
Is it the path that crossed, the path not taken, right, is that Robert Frost?
Snowy, yeah, snowy.
Yeah, it's good, it's not in here, whatever.
It's not a path, no, it's snowy, snowy evening. Snowy. What is that? What is the great? Well, Robert Frost did a bunch of great farm, but snowy.
Yeah, that's what. Robert Frost was a poet.
I know, but what was the great, what was his most famous poem?
The path not taken.
The path less taken?
Not taken.
I think it's one that starts with two.
Don't give me
words
that.
ever,
I was
but
not
took
an
a
English
travel
major.
by.
I got it as quickly as I
He
could.
did a, yeah, it was. There we are.
You've exhausted my poetry knowledge.
There we are, showing what we know.
That's even.
Yeah, it wasn't snowy. And Dan, it wasn't starry night. That was another one.
No, I can
Actually know the beginning.
starting night.
No, the,
No, that's,
Is that the beginning?
the,
I thought that was a painting.
always take the road.
it is. Van Gogh.
It's actually really pretty.
Yeah, it's popular.
I never understood the Mona Lisa. One of the biggest disappointments. It's like this big. It's the weirdest thing, and it's surrounded by all of this and thousands of people. It's a.
Mr. Frost is here charged in 25 CR 1006 with the third degree felony of evading arrest or detention. The motor vehicle. Problem is, we got a prior felony of controlled substance, so this third degree felony can be enhanced one level to a second degree felony.
Okay.
So you're looking at up to 20 years in prison, and it's most serious. And with a prior conviction, you're ineligible for probation in a lot of circumstances here. You couldn't get probation in trial. You went to trial, it'd just be all or nothing, as it were. All right, it's August 13th indicted, and 1 resetting, 2 resettings, 3 resettings, 4 resettings. It's about time. What are we doing today?
Ironically enough, I was going to get one more resetting so we can look at the discovery. We just got the offer this morning. It's a probation offer. Definitely need a long reset, judge. 2 weeks is fine. Is somehow for him to, I think he has chemotherapy tomorrow with the doctor's visit.
2 weeks.
That's fine. We'll have an answer then.
Okay, thank you.
Thanks, John.
Hey, Don.
To clear things up for the court, the road not taken by Robert Frost, 2 roads diverged in Yellowwood, and sorry I could not travel both. And B1 traveler long I stood, and looked down one as far as I could, to where it bent into the undergrowth. Then took the other as just as fair, and having perhaps the better claim, because it was grassy and wanted wear. Though as for that, the passing there had worn them really about the same. And both that morning equally lay, and leaves no step had trodden black. Oh, I kept the first one for another day. Yet knowing how way leads on to way, I doubted if I should ever come back. I shall be telling this with a sigh, where, or rather somewhere ages and ages hence, 2 roads diverged in a wood, and I took the one less traveled by, and that has made all the difference. This has been Poetry Time with Dan at TCF.
We now call 25 CR 1098, the state of Texas versus Elijah Watson. Is that you?
Yes, sir.
Present. With Mr. Dusler, your attorney and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here?
That's right.
Can we proceed in a summary fashion?
Yes, sir. Yeah.
In summary, so this indictment alleges that on or about May 16th, last year, 2025, in Jefferson County, Texas, it is alleged you committed a third-degree felony of evading arrest or detention with a motor vehicle. Do you understand what you were charged with here?
Yes, sir.
This is a third-degree felony, which means if convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
Agreement has been reached where you would be pleading guilty, placed on deferred or unadjudicated probation, which can be up to 10 years in length. It's the court's decision, how much time. But at the end of the day, it really isn't all that important. It's how you do on probation. If you do well on deferred probation with me, I cut it short to 1/3 of whatever it is, 1/3. There is no fine. Are there any other special terms and conditions of
No, Your
probation other than the normal conditions for that type of offense? No? Is that your understanding of the plan here?
Yes, sir.
If I follow this agreement, you have no right of appeal. You understand?
Yes, sir.
How do you plead to this, sir? Guilty or not guilty?
Yes.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty?
Yes.
I was almost hesitating. Is that, are you in on that? Is all that true? Okay, gotta be assertive here. I'm gonna show you what's marked as State's Exhibit 1. Did you sign that document?
Yes, sir.
Did you understand it? Discuss it with your attorney? Or the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence,
Objection.
and without objection, it's admitted. Among other things, this states you are mentally competent to enter your guilty plea. It is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged and any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this is true. It states so help you God.
Yes, sir.
States Exhibit 1, part of the record for all purposes. Is a pre-sentence report waived?
Yes, sir.
I am going to follow this agreement. I'm going to find you are mentally competent to enter this agreement. It is freely and voluntarily made. You know and appreciate the consequences of pleading guilty. There is sufficient evidence supporting your guilty plea from State's Exhibit 1 here to find you guilty beyond a reasonable doubt. But I'm not going to do that right now. I'm going to defer any finding of guilt, place you on deferred or unadjudicated probation so long as you follow terms and conditions of probation. Probation officer will go over them with you, but don't repeat this mistake. It has consequences, and these are serious. You're looking at up to 10 years in prison if you fail on probation and your probation is revoked. Then you'd be found guilty of a felony. You ever been convicted of a felony before? You don't want it. You know how long it follows you around? How long? The very rest of your life. Now, length of time on probation. You got recommended 7. What's state says? There's a good reason. It must be some reason.
Your Honor, I'm fine with whatever, the
7's
evading,
good.
going through it, whatever the
All
court
right.
thinks is.
It'll be for 7. So 1/3 of 7 is 2 1/3. Good. Yep. 2 1/3 years, and then you can move on with your life and get past all of this. What program do we make them attend?
If you want us to, we can put him in the moral recognition therapy program. Critical thinking.
Let me ask you, you have a driver's license?
Yes, sir.
Why not?
I just got my ID already. Just,
Are you gonna get a driver's license?
yes, sir. Yes, sir.
Well, you say, oh, yes, but I mean, everybody's gone, or you should, but you shouldn't be operating a 4,000 pound missile without it. Are you working somewhere?
I have an orientation this one. What this one?
I'm talking about some kind of a driving class.
I can do defensive driving if you want to.
Yes,
Okay.
yeah. This is gonna be a gift for you because you're gonna be ordered to take defensive driving. It will reduce your insurance that you have to operate a motor vehicle along with a driver's license. You have to have those two things, or else you're in trouble. And insurance costs. That will reduce it significantly by taking that class, and it will also remind you that a 4,000 pound missile needs to be operated responsibly. Your life and other lives are at stake. Okay?
Yes, sir.
All right. Please see the probation officer. Thank you.
All right, let's head back up to Michigan and Judge Middleton. He's got a new contestant.
Okay.
That's Mr. Good morning, sir. Are you Carol Haney Kelly?
Yes, sir.
I'm Judge
Morning.
Middleton. You're from Hilbert, Michigan, Hulbert?
Hulbert, Hulbert.
Do you have family down here?
No, I had been down here about 15, I was down here in 2018. I had gotten charged and went to prison down here. And then I just had some friends down here.
Carroll is a Kelly family name. Are you related to Jimmy Carroll Kelly?
No, sir. My biological family of Kellys are in South Carolina.
All right. Well, let's take a look at your deal.
Yes, sir. My stepdad lives in Hulbert. Has been there 25 years.
All right. You also have a parole violation and a methamphetamine charge. And this is a driving suspended and a no proof of insurance. Mr. Tim George, the River City Attorney, is here. Mr. George, you have any input on this?
Your Honor, this looks to be a tag along to the felony. Obviously, the felony is the most significant portion of this. I believe he's up for a PCC today with Ms. Ives. I can speak with her, make sure it's the same incident. If it is, we would likely just package this in with whatever the resolution is.
All right. It occurred allegedly 129 of 26. He's been in custody for 12 days.
Yeah.
Let me look at the calendar here.
Your Honor, may I speak real fast?
Yes.
I've been up there in Hulbert, paroled out of Sault Ste. Marie with Mike Morris. I've been doing really, really well. I mean, if you was to call and talk to him, he would tell you I had a slip up. And that's, I mean.
All right, well, don't say any
Really
more. I
don't.
don't want to do anything that
Okay.
might implicate yourself.
Sure.
Yeah,
fine.
this was, the date of the driving was 129. The date of the meth charge was 128, so I think it's part of the same incident.
Yeah, it's the same situation.
All right. Is Miss Ives here?
She's doing the PCCs next week. So
All right. Mr. Kelly, I'm gonna put you in the waiting room. I didn't realize
That's fine.
this was connected to something else. See if we got an idea. that file number again? 26145 FY. We'll set him aside. Jordan, we're on the home stretch here. All right. David Banks. All right, we return to the matter of People versus David Banks. File number is 24127326. Mr. Banks was going to get a court-appointed attorney, but changed his mind and had an instant pretrial with Mr. George. It says here you're going to plead to 1 count of retail fraud, 3rd degree, and they're going to recommend fine and costs with restitution. Is that your understanding?
Yes.
We're gonna resolve it with a civil infraction, just want me to take it down to the.
Yeah, that'd be fine. Thank you.
Thank you.
All right, you heard me go through the advice of rights. You understand you're giving those rights up by entering this plea?
Yes.
So did you go into the Dollar General store on these occasions and put some candy stickers or use a candy sticker to scan to buy some more expensive merchandise?
Yes.
All right. And here they've got restitution of $161 to Dollar General. Not the $530 that's in the thing. You posted $100 of bond. How long were you in jail before you bonded out?
I bonded right out.
This isn't your style. It's like you ought to be over this sort of thing. But you are accepting responsibility. What are you doing now?
I work.
What's that?
I said I work.
Where do you work?
Middleton.
All right, that's a good job. We don't get many cases from Dollar General. There are several in town. All right, I'm going to call it one day. You got arrested and had to post a bond, credit 1 day. $75 fine, $75 crime victims' rights fee, $50 state minimum fee, and $162 restitution to Dollar General. That's $362. Posted $100 of bond. These $262 due. Can you pay that in 30 days?
Yes.
We'll make that due by March 13th, 26. You're barred from the Dollar General stores for 1 year. It's close to where you work, but you'll have to go to the Shell station, I guess, instead. What shift are you on?
3rd.
So you've been up all night?
Yes.
Go to sleep. This was DUMB. I don't expect you to do this again. It seemed like a good idea to like watch the video. Well, you're owning it. Said he's not asking for any additional jail time. You can use that to pay the fine and costs, credit card, cash, or check or money order. All right. Mr. Banks, you're good to go.
I think.
Also, I don't know why it took them a year and a half to serve that warrant.
All right, let's. Kind of a weird day out in Courtlandia. There's a lot of civil stuff, a lot of landlord-tenant, but there's a few good things going on. Let's go to Louisiana. New contestant there.
The panel to my left is Miss Carolyn Stapleton. To my right is Danny Barra. I'm Jerry Ledoux. Would the staff here at DOC introduce yourself for the record?
Carla William.
Francis Abbott.
Our remote location right now is the Louisiana Correctional Institute for Women. And with the offender, please state your name and your DOC number.
Tiffany Woods, 545546.
45546. Thank you. Ms. Woods, you have a large number of people in your support both here and at the facility and on Zoom. And so we have all of their names recorded for the record. We won't go through all of those at this time. We are going to read some information into the record, and then we'll get started on the interview. So, Ms. Woods, we find that you're a first felony offender, currently serving a 36-year sentence for second-degree murder. You have a parole eligibility date of 9/18/2026, an adjusted good time date of January 29th, 2036, and a full term date of 9/17/2042. Does that sound correct to you?
Yes, ma'am.
Okay. Warden, we appreciate you being here. Would you and your staff introduce yourself for the record?
Yes, ma'am. Good morning. Kristen Thomas, Warden.
Tara P, ARDC Manager. Afton Gaddy, ARDC Supervisor.
Great. Warden, at this time, would you like to make a statement about the offender before we begin the interview?
Sure. Miss Woods, has been here for a good bit of time. She has actually completed her NOBTS or seminary in Blackstone. So I know her and I've talked a little bit in the past. Just I think her NOBTS graduation was just something that she was very proud of. And I think she really does a good job working in the seminary and counseling and mentoring other inmates in the at LCIW. She is not a disciplinary problem. We don't have any issues with Tiffany the entire time that I've been here with her. She is low risk and low needs. I think Mr. Myers is on, so I'll let him talk more. But if she is, she does receive a favorable decision today, she will release to the parole project. So I'm sure Mr. Myers will go into detail on what that will include for her discharge planning.
Thank you so much, Warden. We do have Mr. Myers and several others who would like to speak on her behalf. How would you like to handle that? You want to hear them all? Well, first of all, Tiffany, I would like to hear from you and find out, can you, in your words, tell us why you're before this panel today and why we should consider an early release?
Yes, ma'am. Well, by the time of my crime, I just had my third child. Then I had my fourth child, Emmanuel Anthony Woods. He was born June 23rd, 2005. He was born premature and unresponsive. He was in a NICU for a couple of months. And when he was discharged to my care 2 weeks before Hurricane Katrina hit. Me and my family left our home August the 28th of 2005 because I wanted to save my family, my children. We left. We didn't know where we was going to go, but we ended up in Shreveport, Louisiana. When we arrived in Louisiana, Shreveport, Louisiana, we didn't have anywhere to go. We was homeless. We was just out there. But eventually we found shelter at two gymnasiums for refugees. We went to one of them, we stayed, we had a lot of uncertainties. We was in a large gymnasium with nothing but people. I was afraid, I didn't know what to do, but I wanted my family to be close to me. At the time, my son, Emmanuel, he was still taking his formula, but he was throwing up his formula in large amounts. I didn't know what to do. I was overwhelmed. I was scared, but I still tried to feed my child. I didn't know what else to do, but just to continue pushing. And I asked their dad, Emmanuel, if he can find us a safe place to live. It took him some time to do so, but he eventually found us a home. We moved into that home, and around that time, I ran out of WIC vouchers for my son, Emmanuel. I didn't know what to do. I made the devastating decision. Chased my child's milk, and he was taking his milk because I felt that by him taking it and not throwing up in large amounts like he was when he was taking his formula, I thought he was doing better, but he wasn't doing better. I didn't know how to go about anything but survival mode. When I was giving him his milk, I thought again, I really thought he was doing better. I love all my children. I love every last one of my children. I love my son till today. I love him. And I know he's gone because of me. But I didn't mean to take his life.
Woods, I know it's very difficult. Why don't we go ahead and we're going to go ahead and hear from your son then. Mr. Najon Woods has joined us via Zoom, and we'll go ahead and listen to him. Okay.
Good morning, Parole Board of Louisiana. Can you hear me?
Yes.
Greetings from California, and thank you for taking the time to hear me on this morning. My name is Najon Justin Woods, and I'm speaking on behalf of myself and my 3 younger siblings to express our full and unwavering support for our mother, Tiffany Woods. I want to acknowledge the seriousness of her past actions and the impact that they had. We all lost something that day. My mom lost a son. My siblings and I lost a brother. My aunts and uncles lost a nephew, and my grandparents lost a grandchild, all during Hurricane Katrina, where we already lost everything else. And then we lost our mom physically to prison, but being in prison didn't stop our mom from loving us and mothering us. Even though she was not there physically, she remembered birthdays, sent gifts, wrote songs for us, talked to us on the phone for graduations, proms, and she would always encourage us to help us through our hard times the best she can in the capacity she could. Members of the board, it is my belief that we all need her children. All her children need her, and we long to build our relationship with our mom outside of prison. We all served the sentence with our mom. In her own way, she was there when most family members were not. And I believe she deeply cared for us. Over the years, we witnessed her grow into a new woman. Through visits and phone conversations, my mom has expressed deep remorse for her past actions and has worked hard to address the underlying issues that led her to incarceration. It is my belief that she has shown commitment to rehabilitation through her programming, maturity, accountability, and her new faith in God, which she shares with us regularly. All her children, our extended family, and the communities that we're a part of are all prepared to support her in housing, guidance, and stability. She will not be alone in this transition, and if granted parole, I know that she will continue improving herself and proving herself. I respectfully ask with humility that the board considers us, her children, and our forgiveness and the love for our mother, her progress and mindset and her behavior while incarcerated, and our family's commitment to her success while making your decision. And I want to thank you for taking the time for allowing me to speak on behalf of my siblings. Thank you.
Thank you very much. Very well spoken. We also have Stephanie King, who is here at the headquarters, who would like to speak in support. And ma'am, if you'll approach the podium and direct your comments to the panel.
My name is Stephanie King. Some of you may know me or remember me, and some of you may not. I too was once at LCIW with Tiffany. I served 27.5 years of a 60-year sentence. Before this committee saw in me what I hope you see in Tiffany today. Like Tiffany, I too came from a troubled past and used my time at LCIW to rise and rehabilitate myself. Choose to take advantage of a number of educational opportunities and grow into someone who is doing well today as a law-abiding tax-paying citizen. I remember when Tiffany came to LCIW, she was young and confused and full of greed, but our close-knit family of women took her in and helped her find her way. The turn she has taken has been dramatic and inspiring. She immediately got involved in things once she arrived, taking programs, joining clubs, going to school, and spending quality time with her family doing visits. An incarcerated person's schedule in prison can be very busy, and to be able to work your full-time job, mentor, or help others, fulfill your obligations to running programs and ministries is far from easy. However, Tiffany is doing it and doing it well. She teaches soft skill classes, leads an LCIW choir, and fully gives back to mentees and other incarcerated women in any way she can. She has grown and used the time she has been incarcerated to find her footing and become deeply rooted in her relationship with God. She graduated from the New Orleans Baptist Theological Seminary with a bachelor's degree. Today, she has a community she never had before she worked with, a tight-knit community of women, of formerly incarcerated women who have been with Tiffany along the way, now reside in Baton Rouge. We want you to know that we are still here to support her as we supported her in prison. She is not alone. She will be loved and she will be supported. Today, she has the Louisiana Parole Project, friends, and family completely ready to stand by her side and help her navigate with any issues, situations, or problems she will encounter. And today, I pray you see how far she has grown and all the things she has done to better herself while incarcerated. I pray you see how she has truly transformed her life and become a whole new woman. Thank you.
We also have Carrie Myers with the Louisiana Parole Project who would like to speak.
Yes, good morning, board. Carrie Myers with Louisiana Parole Project here on behalf of Tiffany Woods. You've read her package. You see the Tiffany, the trauma and dysfunction of her childhood and early teens, the chaos surrounding the aftermath of Katrina, and a person who lacked the skills to cope with everything she had experienced. But the Tiffany that's sitting before you now has coping skills, is educated. She went from not having a high school education to now being college degreed. I'm not going to go through all her accomplishments. I'll let her attorney do that. But you can see they're extensive and extraordinary, what she has done. We're here to support Tiffany in her transition. You can see also the family support and community support that she has. But Parole Project is prepared to also do what we do and help her through this transition. She's already been interviewed and assessed by our mental health team, our employment team. She is absolutely prepared for gainful employment. We have a plan for her transition and support systems, counseling, and the other things that she would need. We are prepared to provide her with long-term housing. Out of a tragedy has come something that I think could inspire people. And Tiffany has done that. And we're here to support her, and we ask this board to consider all the factors in this and grant her parole today.
Thank you, Mr. Myers. Tiffany, I think at this point, we have also your attorney, Ms. Hutchinson, and I would like for y'all to decide. Mr. Barra is going to start asking questions. Ms. Hutchinson, would you like to make a statement before or after the questions are asked?
I'd like to go after the questions if that's allowed. Thank you.
Certainly. Mr. Barra?
Well, my questions would be answered by your brief, so I'm prefer to let you.
Okay, so well, thank you all again for considering Tiffany and her case. She comes before you today because of the process afforded to her by the Louisiana State Constitution. In 2023, this honorable board recommended her sentence be commuted to 36 years. And as you know, that recommendation does not come easy. So today I'll spend a little time reiterating what was present in 2023 and what is still present today as she seeks parole at 20 years and about 55% of that sentence. And I know y'all have the brief, but so I'll be brief about it. She has the paralegal certification. She has worked previously as inmate counsel. She has associate's and a bachelor's degree in Christian ministry, and she has hours actually towards her master's degree. And if you see the letter of recommendation by Dr. Sharkey, who's the director of chaplaincy for the Department of Corrections, she talks about how Tiffany kind of has integrated her faith and her ministry into being a choir director. She talks about the choir is not simply about music or performance. Tiffany has intentionally used rehearsals as opportunities for spiritual formation. She regularly opens her practices with scripture and prayer and often holds meetings focused solely on studying the word of God and building godly character. And it just shows you that she's intertwined her education and her spiritual beliefs in the work that she does regularly. So gainful employment through the Louisiana Parole Project won't be hard. She has crew leadership. She has pesticide. She's able to do pesticide, both residential and commercial, as well as serve safe. She's been a mentor. She's done peer ministry, doing rounds at the infirmary, choir director, and she's taught trauma healing. You'll see from Nijon speaking and her talk about Hannah's gift and learning how to add faith in her parenting from a distance, one of the core classes that helped save her. She's volunteered around the prison and programming and speaking to people that come in, and she's a published author. Exhibit 11 is all her publications, writing through her trauma and her grief. She's taken self-help programs, and all of this was started when Tiffany got in, when she sat down and had to recognize the deficiencies in her life at the time of the crime. Her education, her parenting, her mentorship, and the immense remorse and grief that she has for the loss of baby Emmanuel and the separation of her children. She's connected with those who were harmed the most after the crime, and that's her children, the siblings of baby Emmanuel, the grandparents, the aunts, the uncles, the cousins that are all present with you and who support her. Because of her sentence currently, Tiffany will be released one day. There's no doubt. However, today this committee is allowed to control what that release looks like. Today you can allow LPP to be a part of her success. That transition, including substance abuse classes, grief and trauma management, and family reunification, employment services, housing, that provide for a safer introduction into community and a reentry that poses no threat to society. I believe that you all see that those most affected by the crime have forgiven her. And no one is saying that this crime wasn't horrible or devastating.
but they all are saying that they want her home. I think that she has proven by her disciplinary record and what the warden has said that she's put in the work. And we are here to support her, and as well as her family and her children. Thank you.
Thank you very much. We do have opposition, and we will allow Ms. Fitzgerald with the Caddo DA's Victim Assistance Committee to speak. But we'll go ahead and you can ask some questions if you want.
I don't have any questions.
Mrs. Stapleton, do you have any questions?
I'm gonna let Leon speak first.
Ms. Fitzgerald, thank you.
Still muted, Leon. Okay.
Okay. I'm sorry, I'm not on my regular computer. I'm Leon Fitzgerald. I'm with the Caddo Parish DA's office. I'm director of the Victim Assistance Program, and I'm here to vehemently oppose on behalf of my office today. This is a difficult case. It's very emotional. It's heartbreaking. We've heard a lot about the situation that Miss Woods was in with her family having to evacuate due to Hurricane Katrina. And honestly, at this point, my office is getting a little tired of hearing about that because while we don't undermine that, I know it had to be chaotic and stressful and unprecedented, but it wasn't a reason for Miss Woods to not feed her baby. And so this baby was thriving when, yes, he was born premature, but all the records indicate, all the experts have indicated that when he left the hospital at Tulane, that he was thriving, he was taking a bottle, he had gained several pounds since he was born. And so we think that that is significant. This baby, let's see, when he was in the hospital in 41 days, he gained 1 pound and 12 ounces. And after he was released into his mother's care, in 2.5 months, this baby gained 7 ounces. His weight at death was 5 pounds and 13 ounces, and he was about 5 months old. So that's unacceptable. Once the family relocated to Shreveport, they were eventually able to get a nice brick house. If you saw the pictures from the scene, they had made a home. It was well furnished with nice furniture. It had beds. It also had cases of baby food in the photographs. So they were getting baby food in jars for their other child. The refrigerator was well stocked with milk, beer, adult food. So it wasn't like they were destitute and everybody was starving to death. There was an empty box that would have contained a case of beer in the photographs of the scene. So we dismiss the narrative that these people had no choices. They had a vehicle. In fact, the records indicate they had 2 vehicles. They had been to Walmart the day before this happened. Why not pick up some baby formula while you're at Walmart? Or if you have a vehicle, take the baby to the doctor, go to the emergency room. I hope that the board was able to view the pictures that I emailed and see how no rational person could look at that poor, emaciated baby and not do something. Take him to the emergency room, take him to the doctor, take him to a fire station and drop him off where he would have a chance for strangers to take care of him. So I think there were a lot of options that these people chose not to take. All the doctors that testified in this case said that this baby could have been saved, that he didn't have to die. And so I appreciate the comments from Miss Wood's family, My heart goes out to them. They are victims in this too. I can't imagine what it was like for them. I think it's a huge sign of their moral character that they're behind her. But the role of the district attorney's office is to see that justice is served and to speak for those who can't speak for themselves, like baby Emmanuel. There were over 1 million people that evacuated New Orleans for Hurricane Katrina, but how many of them let their baby starve to death? Miss Woods was 25 years old. She had 3 other kids. She wasn't a new teenage mom. She had a common law husband who was there. He had a job at McDonald's and was working. They were getting FEMA money. They were getting WIC. Even when the WIC ran out, there's no excuse for feeding your baby watered down powdered milk. That just doesn't make any sense for any rational person to do such a thing. So, we also had time, the baby, as you all know, died on November 27th of 2005. This case took a lot of investigation and obtaining records, and so Ms. Woods wasn't indicted until September of 2006, which gave us about 10 months to
I'm sorry.
There were lots of psychiatric evaluations. By the way, I'm not sure if the board is aware that this was not the first time that one of Miss Woods's children had suffered from malnourishment. Prior to baby Emmanuel's death, they had been involved with CPS baby formula, and she admitted at her trial that she knew that the baby needed formula. And she had already gone through this, giving a baby watered down milk with another one of her children. So it doesn't hold water, but she said about being the aftermath of Katrina. Ma'am?
We're having a lot of computer
Can you hear me?
interference. Can, yes.
Not now.
I don't
hear
have
you.
good internet. I'm sorry. Can you hear me?
Yes. Okay.
She's calling in.
I think we got the gist of it. Ms. Fitzgerald, because of the computer issue, I think we've got the gist of what you were communicating. Okay, so thank you very much for your comments and being with us. So now, does the panel have any questions, Mr. Balrog?
No questions. Leon answered my questions.
Okay. So we've heard from everyone. Tiffany, I'd like to give you one last opportunity to make a statement before the panel would vote.
First and foremost, I will say thank you for this opportunity. Secondly, I understand that this crime shouldn't have never happened, but it did. I did not intend to harm my son. He's gone. I cannot get him back. I wish I could. I tore my family apart because of the decision that I made. There's no excuse, and I'm not sitting here making one. But I can say that I love my children, every last one of them. Always did, always will. I was a young mother, yes. But at the end of the day, I was still a mother. I tried my best. And sometimes your best is not good enough. But I can say that I did all that I could have done. And the pertaining to my son's passing, I had a hand into that. And I tore everything apart. And I cannot say that I can't get it back. And I wish I could. I wish I could get him back. But he's gone. But my children that remains is still here. And I would love to have a relationship with them outside of here. I can't say that just because Katrina happened, that's an excuse. It's not. But Katrina did happen. And I left because I wanted to save myself and my children. Foremost, I wanted to save them. And again, I can't say nothing else, but I'm not that person that I was back then. I grieve my son every day.
Thank you. Appreciate it.
If I may, can I just clarify just a couple things from my record?
I don't think at this time it would be appropriate.
Okay.
All right. I'm assigning the case, so I'll get to be the one to vote first. Before I vote, I do need to acknowledge that you're doing a good job where you are, that you completed a lot of good programs, which we didn't get into a whole lot of details about, but there's a lot of programs you completed that are very good. You have a low risk on your Tiger score. You got many letters of support from friends, family, employees. You are a true first offender. This is the first crime you ever committed. And there's no victim opposition. We have law enforcement opposition, but no victim opposition. So all of that being said, I'm going to vote today to grant parole to the parole project for a minimum of 1 year, that you take mental health classes, substance abuse classes, parenting classes, whatever they have to offer at the parole project. I want you busy with classes the whole time you're there.
Or a job.
And what?
Or a job.
And a job. Ms. Lou said, or a job. I said, and a job. So we want you to be busy. And that's my vote.
Stapleton.
I agree with everything that Mr. Byron just said. Everything. And then I saw the pictures of the baby. And then, we heard Leon describe the situation. Based upon what I saw and what I heard from Leon as reasons why they indicted you and you were found guilty of the crime of second-degree murder. You did get life, and then it was reduced to 36 years, of which you served half of, 18 of the 36 years. And you've done remarkable, wonderful things. But because of the condition of the child and the circumstances that the DA's office described, I am not going to be able to grant you parole today, and extreme law enforcement opposition.
Ms. Woods, my vote today is grant parole to the parole project. You have you pose no risk to public safety. You have done an excellent job of rehabilitation. Your conduct has been very good, and your plans for reentering are excellent. But at this time, you needed a unanimous vote. So today, your parole has been denied. We wish you well. Thank you very much. And that concludes our business there at LCIW.
Denied.
So before we go back to court, let me speak here a minute. Simply Google Tiffany Woods, Louisiana, and you'll find a multitude of articles and material on this. Some for, some against. There's a lot going on. So initially, she was found guilty of second-degree murder, which she's still guilty of. But interestingly, second-degree murder, and I'm reading right out of the Louisiana Code right now, whoever commits the crime of second-degree murder shall be punished to life imprisonment at hard labor without the benefit of parole. Somehow, despite that, they managed to convince this board in 2023 to recommend a commutation to 36 years, which was apparently agreed upon by the governor. So she already got a gift that I don't know how they managed to manipulate in around the Louisiana Code, but they did. So there you go. Now, again, there's a lot of material out there for and against this lady. And I'm walking away from this torn. I know there's a lot of unlike for her in the chat, and I would tend to agree with that. But there's probably a little more to this story. I'm basing it off a little bit of experience. One of the children from my first marriage rejected almost every formula we threw at him. Couldn't get anything to work, just constantly throwing stuff up. Wasn't interested in breast milk, just how do we feed this child? And it ended up being one specific soy formula that he could end up tolerating. And even then it was a lot of throwing it up, but not as much, and it was enough to keep him nourished. But he was also born a very big baby, so very strong to start with as well, unlike the preemie here. So I think at a minimum, what you've got here is somebody completely uneducated on how to take care of their child, at a minimum, which at that point, at some point in your brain, it has to kick in, okay, nothing's working, I need to go seek help. And go seek help, which didn't happen either. So, I think that, in my opinion, I think the fact that she's denied parole is probably the right call. She didn't do enough to take care of her child for sure, but there is part of me that believes that there's more to this story, not excusing it, but I think there's a possibility here that you had a very uneducated person as far as how you can have feeding difficulties with children, who at best tried to wing it and didn't seek the help they needed. Those are just my thoughts on it. But again, simply Google Tiffany Woods, Louisiana, and you'll find all sorts of material out here on this case, regardless of how we got here. 20 years ago, a baby died, and a family's broken apart, and none of it's good. So just my thoughts. Okie dokie. All that having been said, back to Texas and Judge Stevens.
And in fact, you play him more intellectually, and it looks far better when you do it.
Okay, I'll
When
take
you
it.
do the impression.
Sure.
But do you know where Mr. Burbank is? Do you know where he is?
No, sir. I seen his truck outside, so.
You did?
Is he in
Yeah.
trouble?
You seen something else? But he would have told us. That would be the responsible thing to do. Oh, I see. He filed a motion to withdraw his counsel. Have you talked to him about this?
I just talked with
It's in here, but then there's a hold question mark on the. This is fine. Back in September. But he hadn't Are you taking care of, generally, this has a lot to, you've paid him, right?
Yeah, I still owe him a little bit, but
Okay.
that,
Was that done because you hadn't paid him or something?
yeah, that was back in,
September.
yeah.
But it's, the thing is,
Like every
it's
time-
still in the file and he didn't withdraw it for some reason. And,
Every time I done came here.
but he was here back in December,
Yeah, I think I've been
December
twice.
29th.
Yeah.
And it said, man, let me tell you, we've got a lot of resettings.
Yeah, about 5 years.
Well, it's running out of it's April 21st is when it was indicted.
Yeah.
This is not old, it's ancient
Yeah.
compared to, okay. But you haven't talked to him about this today?
No, yesterday I talked with the office. They said he would be here this morning. So,
Only in their dreams.
Have it, our office doesn't hurt from office is not hurt from Mr. Burbank. Sure. What is that?
All right, well, what I want you to do is stick around for a little bit and see if he shows up. We're about, though, to go into a trial, but I can stop it briefly and take care of something if it's just one matter. But this is, no, we're going on 5 years old and there's no excuse for that. We have to fish or cut bait. That's
yes,
it today.
I agree.
Well, I mean, look, I've always been wanting to move forward on it. Y'all's issue, not mine.
Yeah, I think it's Mr. Laird's. It looked like it was set before, Your Honor, on the trial docket. I don't know if then Mr. Burbank got on and asked to have it removed to talk to Mr. Jones, but it was set before on the trial docket a couple of times.
Yeah. And then I had a lawyer and he just went missing. Yeah, so that's how I ended up getting Mr. Burbank. So yeah.
Let's see if I can guess who that might be.
It was a guy from Houston.
Okay. Yeah. Yeah, I pulled it and there it is, no show.
Yeah.
Of all these, I pulled and there it is right there.
Yeah, he actually didn't show the court a few times.
Well, that's no way to handle the responsibility of a human life that you have in your hands.
It took my money. Yes.
Well, there are ways of dealing with that if you need to. Yeah, talk to Mr. Burbank. He'll help you. But let's wait. We're going to have to go into this trial. I hate just to hang around, but we're going to try to find him so that we can get something. Thank you, Reagan, very much for standing in. But
Just step next door. He may be next door.
He has people on the docket at 2:52, so maybe he's next door.
I don't know why that's always more important than my court for some reason. Especially when we got 602 trials. I think we're good.
Hey, Ed, you're number 12 on the talk is.
Yeah.
How come? I'm not surprised. Okay, we are in short recess.
So sidebar crew, you know, a lot of stuff still going on in the chat about that Louisiana case. Think about it. Think if this should be at least the basis for our Thursday topic, because we need one yet for Thursday. So think about that, because it feels like we could definitely have a longer discussion on this matter. Just an idea. Let's go to Florida. Brantley Clark is doing felony hearings. Let's see what's going on there.
Would be withheld, will be on probation for 24 months, stipulates to all court costs and fines, restitution in the amount of $200 to Tavon Beaton. He'll serve 100 hours of community service, $20 a month cost of supervision. He'll provide a DNA sample, forfeit any seized items. We stipulate to the facts for the purposes of the plea, and he'll have no contact with Mr. Beaton.
That's the agreement with the state?
To an unlawful use of a two-way communication device.
All right, sir, you can lower your hand and state your name.
Jeremiah Ingram.
Mr. Ingram, you just heard the announcement of Ms. McLaren, is that correct?
Yes, sir.
Is that your understanding of the agreement with the state?
Yes, sir.
Has anybody promised you anything different?
No, sir.
Are you under the influence of any drugs or alcohol this morning which would impair your ability to enter the agreement
No,
or
sir.
understand any of the terms and conditions of it?
No, sir.
I've been handed a plea waiver consent form. There's the front page. On the second page is the signature of the defendant line. Is that yours?
Yes, sir.
Have you had a chance to read that agreement?
Yes, sir.
Have you had the opportunity to go over your case with Ms. McLaren?
Yes, sir.
Have you had sufficient time to speak with Ms. McLaren about your case?
Yes, sir.
Are you satisfied with your lawyer's advice and counsel?
Yes, sir.
You understand that by entering the plea, you're waiving your right to go to trial?
Yes, sir. I understand.
You're waiving your right to require the state prove the allegations against you.
Yes, sir.
You're waiving your right to have your attorney cross-examine the state's witnesses and contest their evidence.
Yes, sir.
You're waiving your right to present any defenses you may have to the allegations.
Yes, sir.
You're waiving your right to subpoena your own witnesses to come to court and testify on your behalf.
Yes, sir.
You're waiving your right to testify or remain silent at the trial, which would be your decision to make.
Yes, sir.
You're waiving your right to appeal anything but an illegal sentence.
Yes, sir.
Are you doing this for your own free will?
Yes, sir.
Mr. Ingram, do you feel the pleas in your best interest?
Yes, sir.
You understand if you're not a citizen of the United States, you may be subjecting yourself to deportation proceedings by entering the plea?
Yes, sir. I understand.
Is the state or defense aware of any DNA evidence that exists which might tend to exonerate Mr. Ingram?
No.
You stipulated the prima facie case?
Yes, sir.
Now I need a call sheet also. I am going to accept the stipulation, find there's a prima facie case. I'm gonna find that Mr. Ingram's plea was freely and voluntarily made. After consultation with his attorney, I'm going to accept it. I'm going to withhold adjudication of guilt as to the unlawful use of a two-way communication device. He'll be placed on a term of probation not to exceed 24 months. He's ordered to pay fines and costs, and that was at $1,253. There's restitution in the amount of $200 payable to Ahmad Beaton. He must do 100 hours of community service work at a minimum of 8 hours a month through the Bay County Work Program. I'll give the Florida Department of Corrections the discretion to amend that at the direction of a probation officer. His cost of supervision will be $20 a month. If he's required to give a DNA sample, he must submit one. He'll forfeit any seized items. He's to have no contact with the victim or any co-defendants. Mr. Ingram, you have 30 days to file your notice of appeal. If you wish to appeal your judgment and sentence, if you'd like to have an attorney to represent you, you can't afford one. One may be appointed to represent you at no charge. Good luck to you, sir. You step over and speak to the probation officer.
Yes, sir. Thank you.
Yes, sir. Oh, he needs a waiver of extradition? All right, yeah, and you go ahead and sign that.
Right here. Georgia.
You can call your next case.
Next one I have is Matthew Faladian, case number is 253131 CFMA. Mr. Sullivan. Judge, we've received discovery on his case and requested deposition times.
All right, do we have the deposition set?
I don't believe so, but let me check. They picked him up, though.
Do what?
I thought he was in federal custody. So currently he's been released from that as well.
We do not have a date yet. I'll follow up on that today.
Are the feds got federal charges?
Yes.
They've adopted this case.
What are we going to do? Just
I thought he was in custody. I was going to ask for him to be taken off the docket and a hold placed on him, but if he's released on those charges, then I guess we gotta just keep tracking until.
And we filed a waiver for him once he got out.
all right, let's set it
Yeah,
for
maybe 6 months from now.
yeah. Let's just set it for June 9th at 9 o'clock and see where they're at.
Next one I have is Betsy Godfrey, case number is 251608 CFMA. Mr. White.
All right.
Judge, we brought a restitution check to the state attorney's office in exchange for a PTI. We haven't received the PTI yet, but as soon as we do, we'll get it entered.
Got nothing to do with any of that. Not one thing. That's not me. Y'all do all that and I don't even want to hear about it. I'll set it for March 10th and I'll see what you can do. I don't know what you're doing. For the record, I didn't get no check.
Judge, I'm covering for Ms. Goldhagen this morning. She has Jesus Casanova, case numbers 25-2584 and 25-3068 CFMA.
All right.
And I believe she has deposition set for March 9th, so if we could get a date after that.
April 14th.
Then I believe she's also handling James Fogel with Mr. Pereira, case numbers 25-3120 and 25-3158.
Okay.
I don't believe there's been an offer made yet. I know he's had victim contact, but
They took over. I know we sent discovery and I'm kind of waiting to see what we're gonna do from here.
All right, you think you know anything on, and she got both cases?
I think Mr. Seifert is the attorney of record on Fogel.
On one of them.
Okay. All right. You think you'll know something March?
Yeah, we'll see what they want to go.
All right, March 10th at 9 o'clock.
Thank you, Judge. That's all I have.
Have a good.
All right, everything's pretty procedural over there at the moment. Let's head to Texas and Judge West.
Reject that again and go back to trial docket.
Okay.
And I don't think anything's changed about the offer either.
Okay.
You agree?
Great, Kim.
Right, it's the same offer, 30-year cap.
It looks like previously
It may have been,
to reduce the charge or to,
no, that's what they were requesting. That I do. Have no count.
not. Anyway, okay, can't read it.
My handwriting, I suspect.
All right, you're Ava Musgrove? Yes, Sharon. And in clause number 25, DCCR 0048, Ms. Musgrove is charged with the first degree felony offense of murder. And that's from December 29th of 2024. And what that means, ma'am, and we've gone over this before, is that if you go to trial and you're found guilty, the range of punishment would be between 5 years and up to 99 years or life in prison. Do you understand?
Yes, Sharon.
And I have a plea bargain rejection that you've signed here today with Mr. Gertz that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a cap of 30 years in prison, which means you would be leaving your punishment up to me. I could give you 30 years. I could give you less. It would depend on any information that was brought to me at a sentencing hearing. You have every right to reject that and have your case set for trial. I just want to make sure you understand possible consequences if we go to trial and what your options are. And do you understand all of that?
Yes, Sharon.
And do you want to reject that offer and have your case set for trial?
Yes, Sharon.
All right. And so based on kind of some of this back and forth, is there any reason to believe anything would change with regard to that offer?
There we go.
So I want to make everyone, make sure everybody's clear that there will not be a plea. This plea agreement will not be accepted after today. So it's either trial or a plea to something different unless there's some new evidence that's discovered that you guys don't have for some reason at this point. Do you understand?
Yes, Sharon.
All right. And as far as you know, everything's, you have all the discovery and.
As far as I know.
Okay.
All the
Any,
stuff,
you're not waiting on anything?
No, I don't know anything that's still out there.
Okay, we'll get it set on the next available trial docket. You can go back with the bailiff. Okay. Mr. Rojas, you have Marco Gomez. So on Gomez, hold on. It's a plea?
It was going to be, but then the victim called last minute and changed it. Decided she didn't want that there.
Okay, so I can delete
You can
that
delete the paperwork.
registration. I didn't get the rest of it. I just got the registration.
Yeah, you can do.
Good morning. Are you Marco Gomez? Speak up, please. And this is clause number 21-3623 534, and Mr. Gomez is charged with sexual assault, set for trial to begin with jury selection on Monday, the 23rd. And what is the announcement?
Great. Stay true.
All right, obviously, this is one of the oldest ones we've got, and so I would anticipate that it would be pretty high on the list, if not the top. Is there anything that you guys need me to know or we need to discuss before I number those cases today?
No.
All right, it looks like there was a previous rejection back in November. No changes or to that. That was for 15 years.
That was the offer we rejected, Judge. We had actually signed paperwork this morning for 8. After we signed it, I think the complaining witness called Mr. Smith and expressed that she did not want the 8-year offer. And so that was withdrawn. So
Okay.
we're here back at the trial docket.
All right, so then I'll set it. There won't be any plea agreements after today. Mr. Gomez, if you change your mind and want to enter a plea of guilty, it would be open to the court or to some other number other than that 15. Is that where y'all are at 15?
That's where we're at, Judge.
Okay, all right, then I'll set it and we'll probably see y'all at 1 o'clock on the 23rd. You can go back with the bailiff.
Judge, I have Willie Pugh.
Yeah.
Just need a reset on that. He's looking to hire in his own term.
Let's get Mr. Pugh, Willie Pugh. Willie Pugh.
Well.
Thank you, Judge, for putting that detective in.
Yeah, no problem. All right, are you Willie Pugh?
Yes, ma'am.
And this is 25 DCCR 1835. Mr. Pugh's charged with unlawful possession of a firearm by felon. Mr. Pugh, Mr. Rojas has let me know that you or your family are trying to hire a lawyer. Is that correct?
Yes.
So are you asking me to reset your case a little bit to let y'all do that?
Yes.
So what I'm going to do is about a 30-day reset, which is a normal reset. If y'all get someone hired, they'll do the paperwork to substitute in. If for some reason you're unable to hire someone, Mr. Rojas is still your attorney, will remain on your case. And when we come back at that 30 days, if you haven't been able to get one, then we'll need to move forward with Mr. Rojas, okay?
Yes.
All right, you can go back with the bailiff. Thank you, Mr. Rojas.
Thank you.
You've got Brian Trejo.
We've already taken care
We
of
already
it.
did that.
Unless you want to reconsider.
Nope, I'm good. Thanks. Forgot. Oh, this Robert Lowe, we had him come back to do the registrations. I was wondering why that was here. Let me get those out of my queue to use. I don't think so. We just needed him here, I think. Who was his attorney? So that's good. Let's see, Mr. Salinas on Carlos Rodriguez.
Hold that for 1 second. Let me ask Ms. French.
Sure.
She's perhaps not good. At least she was 8 minutes ago.
Mr. Wilkerson, Mr. Vasquez. Okay.
You swear.
Let's see, Mr. Gertz, you have Giovanni Coleman.
I do, Judge.
Giovanni Coleman.
Right.
Do you hear how relaxed it is in here? Like, in Harris County, I'm usually thinking in Harris County, it's like, you show up if you want, you don't, but it's weird. It's like, really? Guess because I've been nice on it, maybe. So far, anyway. Good morning, you're Giovanni Coleman, and this is 25 DCCR 0479. Mr. Coleman's charged with murder. Mr. Gertz, what is the announcement?
Judge, we're going to ask for one additional resetting. There's a number of reports and videos in this case that involves, I would say, pretty hyper-technical cell phone and block evidence. So block evidence is photographic evidence. Okay, sorry.
Thank you.
Sorry. Is this your first day?
It's
my
not,
first day.
it's not my first day, but I appreciate that.
I apologize.
That's okay.
I'm so sorry. Either way, that a lot of the mapping and location and work that was done here just needs some additional review, in my opinion. And so, and then we were able to find very recently a ballistics report that was not labeled ballistics report. It was labeled like F-25 and didn't have any content. And so anyway.
So I'm gonna do one more. It looks like you have been on since May 2nd, so it's getting time for an announcement. I'll do another reset, but we need to see if we can get an announcement at that next court day. Okay.
Good. Thank you, Chuck.
Stay in touch. He'll stay in touch with you.
She'll tell me.
See, you've got me thrown off
Yeah.
now. Ronald.
Wait till this next case.
Ronald Spites.
I need a couple minutes on that, Judge.
Okay.
I'm going to be asking for more time on that. So if you want to call him out,
I can get it done if that's what you.
I can do that. I just need to talk to him too. So
Spites. We can ask him to keep them for a second after. It's me. Good morning, sir. You're Ronald Spikes.
Yes, ma'am.
This is 25 DCCR 0920. Mr. Spikes is charged with manslaughter, and Mr. Garst, what's the announcement?
Judge, we're asking the court for one additional resetting on this. I need to sit down with him and just haven't had a chance to talk in detail enough about the allegations here and the evidence that they have provided us, which I believe downloaded everything that has been uploaded. So.
Okay. Anything that you know of that you're waiting on? All right. So Mr. Spites, what I'm going to do is now that Mr. Garst has everything, he'll be out there, I'm sure, to go over all of the information and discovery that he's received. And then we'll see where we are at the next court date. Okay. Thank you. Ms. Holmes?
Yes.
You've got Tristan Calhoun, the sentencing.
Yes.
And thank you for taking care of Mr. Lowe.
Yes, ma'am.
One and also. Good morning, sir. You're Tristan Calhoun.
Yes.
And Mr. Calhoun was previously in court, entered pleas of guilty in clause numbers 25 DCCR 1216 and 1217. I've received the pre-sentence report as well as it looks like 2 memos from probation that were follow-ups to that report. Have you all had an opportunity to review all of that?
Yes, Your Honor. I have, Judge.
Are there any additions or corrections to that pre-sentence report?
The only correction we had was under the substance abuse history. I believe they their alcohol date of first usage, it should have been 18, 19 years old, not 8 or 9 years old.
Oh, okay.
Yes, ma'am. But that was the only correction.
Okay. Thank you. Anything?
Judge, I would just like the record to reflect that my office made multiple attempts via a regular victim contact letter with both of the complainants in these cases in order to try to obtain a restitution amount via that letter, via a restitution request form. I then was able to work with Ms. Roach, who did some investigation on it. And we have an investigator to find different numbers for those young ladies. They were able to reach out to them and have them call to the probation department. As of this time, unless it's somewhere in the paper sphere, I don't have a restitution amount from them. I understand their concerns that they voiced, but I believe that the offer was appropriate based upon his lack of criminal history and the severity with which the court can punish him on any type of revocation. I don't know how Your Honor would feel about ISF based on his age, but I would suggest maybe at least considering the positive track of ISF.
And Your Honor, I have spoken with Mr. Calhoun in regards. I told him there could be restitution in the future if anything is provided.
Well, if it's not ordered today, there will not be any.
Okay.
So that's why they attempt to get all that information. And it sounds like the district attorney's office and the probation office has made a diligent attempt to try to get any number. And so there's no coming back later for restitution, so we'll just have to go forward without that. Mr. Calhoun, I'm going to find in each of your cases that you entered your pleas of guilty freely and voluntarily. And in cause number 25, DCCR 1216, find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney's office and defer all proceedings and place you on probation for 7 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. And I'll go over some of those in just a few minutes. And then in cause number 25, DCCR 1217, also find sufficient evidence to find you guilty. However, I'm going to follow that agreement and defer all proceedings and place you on probation for 7 years. You'll be ordered to pay a $500 fine in that case as well and to follow all of the rules and conditions of probation. I am going to order that you enter and successfully complete the JCDI program. It's an outpatient treatment program. That's what was recommended after that substance abuse assessment was done. I'm not going to order any further upfront or ISF. I think you're 28 or 29.
28.
Okay. This seems very, very out of character for you. And this was a terrible day, and what you did was terrible and affects at least one of these ladies has some significant issues and probably will forever based on this. But I mean, you have no criminal history, and so we're going to get you the help you need, and hopefully you can be successful on probation and not have any issues. So what that means is you don't have felony convictions on your record right now. And if you successfully complete these probations at the end, the case will be dismissed, both of them. You'll never have a felony conviction. So it's a great opportunity that you're getting today.
Yes.
The other side of that, and part of what Ms. Molfino was stating, is that if you violate any condition of your probation, you can be brought back into court, and then I could find you guilty of both of the offenses and sentence you to prison for between 2 years and up to 20 years in prison. Do you understand?
Yes, ma'am.
So I'm handing you in each of your cases the trial court certifications that shows these were agreements that I followed, and so you have waived your right to appeal. Probation will talk to you before you leave the courtroom today. It's very important that the first thing you do when you are released is go to the probation office and make sure to get everything started and lined up with them.
Yes, ma'am.
All right, yes, ma'am.
Sorry, just if I may, so
Take
the
these.
record reflects and in the instance that anybody is observing. Of course, I would not hesitate at all to put those victims in contact with victims assistance for on victims compensation.
Yeah.
Based on these pleas, I think that would be an avenue that we can travel down, and that I don't want this to obstruct that, but I understand the restitution amount. I did not have support today.
Sure, and there are definitely some avenues, if they get in touch with the district attorney's office, that might could help them with some of that. Okay, thank you, Ms. Molfino. You can go back with the bailiff.
Thank you.
Yes,
Thank you.
all right, careful.
Okay, let's change it up a little bit. Let's go back to Michigan, but let's see what's going on with Judge Mertz.
All right, Mr. Ackerman, are you able to hear me okay?
Yes, I can.
Okay. And looks like we have everybody else connected. So we'll go on the record in People versus Travis Ackerman. This is file number 245312. The record should reflect that Mr. Ackerman is appearing today by video from Crawford County Jail. And we have Mr. Thompson here appearing on behalf of Mr. Ackerman for purposes of arraignment today by Zoom. We also have Mr. McFell present by Zoom, the probation agent. Mr. Ackerman, you're before the court today for arraignment on two alleged probation violations. Do you understand why you're before the court today?
I believe so, yes.
Okay.
I talked to Jason Thompson earlier today, so.
Okay. Good. All right. Mr. Thompson, did you have an adequate opportunity to speak to Mr. Ackerman?
I did.
Okay. Were you able to go over Mr. Ackerman's rights with regard to the alleged violations and maximum penalties and so forth?
Yes.
Judge, I do want to make just for the record, when it was filed, it was a technical, but based upon beyond 60 days, and that would make this now a non-technical for failing to report.
Okay. All right. So Mr. Ackerman, what that means is that if you are found guilty of the alleged violation in this case, because it's a non-technical violation, it could subject you to the maximum possible penalty on your underlying charge, which is possession of methamphetamine. That's 10 years. Do you understand that?
Yeah.
Okay. Mr. Thompson, were you able to discuss how Mr. Ackerman wanted to plead today?
Yes, Your Honor. I think Mr. Ackerman disputes the original charge. However, I believe he would admit that he did not attend the hearing on the 10th and that he has not reported since October.
Okay, so do we want to enter a plea today?
As to the new allegations, yes, I believe he was.
Judge, if he pled to the count one on the new allegation of failing to report on 10/1 of 2025, which is a non-technical violation, I would just dismiss the original charges along with the failing. If he pled to the new violations, I guess is what I'm saying, is a non-technical, I would dismiss the ones from back that we originally filed. I did do some follow-up, with Otsego County, and they still have not charged him criminally there yet. And I reached out to the trooper today, and he was going to do some more investigating on that. But I would dismiss that violation, Judge, if he pled on the new one.
Which is all right. So, Mr. Ackerman, did you wish to plead guilty here today?
I guess I'm a little bit confused. I don't understand what, like, on my charges. Okay, so if I really need to, I feel like I would like to talk to Jason more on that before. I mean, if that's the case, because like if the original charges are dropped, then the violations for not showing up to court are for those charges, correct?
That's correct.
So
There's
those
also,
are dropped.
Judge, he also didn't report. I mean, he hasn't been reporting. There's more to it.
I reported up until I got those charges that are going to get dropped.
Travis, you got out of jail. On September 17th. I gave you a reporting day of October 1st, and I have not seen you since.
I was reporting over in Bel Air County to John Morley is where I was being reported to, which I had no problems with, none of that stuff. And then the charges of non-reporting police contact, which I did report police contact to John Morley over in Bel Air. And that was what my violation was not reporting to that and possession of drugs that I didn't have possession of. On the date that the trooper, that he said he talked to the trooper, Cody Dole made me call my probation officer before I was able to make another phone call on the side of the road
Mr. Ackerman, just hold on one second. Mr. Thompson, are you representing Mr. Ackerman for this hearing today?
Yes.
Sorry.
Do you want him to go into this stuff, Mr. Thompson?
No, I think we probably need to set it at this point, Your Honor.
All right. I mean, I guess I would appreciate you're representing Mr. Ackerman as his counsel here for purposes of this hearing. I feel like maybe you need to step in and stop him from making statements like he's making here on the record. Right?
I apologize, Your Honor.
You don't have to apologize to me. I mean, I'm trying to look out for your rights. I don't know why Mr. Thompson isn't stopping you, I guess, is my question. But that's up to him, I guess. So, Mr. Ackerman, it sounds like you do want to contest the allegations, which is fine. And you have the right to have a hearing as to whether or not you violated your probation. And so we will set this for a hearing and you'll have an opportunity. Mr. Thompson, did Mr. Ackerman request court-appointed counsel?
I was appointed on the original violation, Your Honor, so that would continue.
Okay, so Mr. Ackerman, you'll have a chance to go through that with Mr. Thompson prior to the next hearing, and then we'll see where we go from there. So the court will set that for a hearing. I'm going to try and get this on for next week. I have a date there on a week from today in Crawford County, so I'm going to try and get it set for that date. In terms of bond pending that hearing, Mr. McFalda, do you have any recommendations?
Judge, I just, we set bond at 10,000 cash surety back on September 15th of 2025. He posted that 2 days later, and I had not seen him since. So I guess I don't know what kind of bond would be set. I would think something higher than what's already been set, Judge.
All right, thank you. Mr. Thompson?
Your Honor, I understand there's some allegations of issues with appearance here. Mr. Ackerman has strong local ties and he has family in the community. I'd ask the court to set a reasonable bond. Thank you.
All right, given the nature of the underlying charges, the fact that Mr. Ackerman did not appear for a court hearing back in October, and apparently has not been heard from since, the court is going to set bond in the amount of $5,000 cash or surety, with all standard conditions of bond and all terms and conditions of probation. The court will again set this for a hearing next week, and we'll go forward at that time. Mr. McFall, anything further for the record here today?
So I just let Mr. Ackerman know yet again, if you postpone, you are to report to probation, not just that day, but following subsequent to that, the dates that I give you.
Absolutely.
And I just want to make the court aware, Judge, I am leaving on vacation here starting the Thursday of this week. I will not be here on the 17th, but I'll try to make arrangements to have whatever ready to go for whatever hearing we may or may not have on that date.
Okay, thank you. Mr. Thompson, anything further from your side today?
No.
Okay, all right, thank you. That's all for this hearing.
Well, that was interesting just to listen to the judge get on the defense attorney for not doing his job. Let's go back to Judge West.
You're James Gwatney?
Yes, ma'am.
And Ms. Holmes, will your client waive the formal reading of the indictment?
Yes, Your Honor.
Mr. Gwatney, in clause number 25 DCCR 0736, you're charged with a third-degree felony offense of failure to comply with sex offender registration requirements, and that's from March 5th of 2025. And how do you plead to that charge?
I guess guilty.
Well, there's no I guess. Either you did it or didn't do it. So are you guilty or not guilty?
Guilty.
Are you entering your plea of guilty freely and voluntarily? Answer out loud, please.
Yes.
Did anybody force you to plead guilty today?
No.
Okay. I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Ms. Holmes?
Yes.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Gwatney is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, and at this time find you guilty of failure to comply with sex offender registration requirements, sentence you in accordance with your agreement to a term of 2 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I've handed you the trial court certification that shows that this was an agreement that I followed, so you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes. All right, good luck to you, sir. You can go back with the bailiff.
Can I ask you one question?
Sure.
Whenever I was brought back from Oklahoma, I had 6 months left on my 3-year sentence. They sentenced me to ISF until discharge. Why was this charge that is being brought up on me now not brought up on me while I was being incarcerated back in ISF for the last 6 months?
How would you think I would know that information? I have no idea. I have no idea. I mean, I
have gone over the time frame with him from what he told me, the time frame that he was in ISF was after this case was filed.
Yeah.
Case has been indicted over 6 months.
Yeah,
Yeah, and
I don't
he-
know. I don't know why that didn't happen, sir. I'm not sure if it was something.
Charges were supposedly filed in June of 24. And I was arrested in 25.
These charges are from March of 2025, sir. And you just pled guilty to that and it's done. You got your 2 years. You can go back with the bailiff, okay?
Okay.
I don't know the answers to those questions. Mm-mm. I just, I'm still. It is. I just missed my note. On camera.
Okay. Oh, geez.
Mr. Lewis, okay, you've got Michael Murillo. Let me give me just a second on that one. It's gonna take a minute. Let me see if I've got something quick to take care of. Took care of that, took care of that. What about Joshua Smith?
We're gonna, I talked to Mr. Smith and we're gonna need a reset on him, Judge. We need to take out his criminal history.
Okay.
Compared to.
We're gonna reset Joshua Smith. I'll give y'all some time to get that checked on. Yeah. Okay, here we go with. I don't know if this one wouldn't be easier. 1, 2, 3, 4, 5, 6 indictments that I've got. I just think it would be easier probably if you start printing from the back, start printing from 15, 17, and I'll start printing from the top and then we'll. A song just came into my mind. We'll meet in the middle. But I will spare everyone from me actually singing it. I'll just sing it in my head.
Okay, friends. Well, she's kind of hit a lag in the action. I looked through my other court feeds and there's not much going on there. And we're only a couple of minutes before I need to call it a day. So I think we're just going to go ahead and call it a day. Again, apologies for no 4th hour today, but I have other fish that are in desperate need of frying. But we will be back tonight, 8 p.m. Eastern, 5 p.m. Pacific for Sidebar. Be sure to join us for that. It will be fun. We're going to talk about showing up in court drunk, because we saw that the other day in Judge McNally's court, and it's not the first time that we've seen it, and it won't be the last. So that will be the impetus for our discussion, and at some point it will devolve into food or something like that, because that's what we do on Sidebar. We talk and we have fun. And, of course, I'll be back tomorrow for this show, 9 a.m. Eastern, 6 a.m. Pacific, a half an hour earlier if you're a channel member. Do go have yourselves a good Tuesday, and we'll see you soon. Take care. God bless.